Good morning. Good morning. It's Friday, May 3rd. I'm not going to be streaming tomorrow, so May the 4th be with you in advance. Replay crew, love you. All the timestamps will be down below. We need to talk about scheduling today. It is day 4 of the Commonwealth versus Karen Read. We are, 9 witnesses in, 8 witnesses in? I have it in my notes. I looked at it before I started and still forgot. 9 witnesses in for the state's case in chief. Remember, this goes the Commonwealth. I will try not to say the state, but I was a state prosecutor for a very long time. So it's trying to switch Massachusetts. No disrespect meant. The Commonwealth's case in chief, they put on the bulk of their evidence, their case. Then the defense case. Then the Commonwealth can bring rebuttal witnesses if they need to. We saw that happen in Depp v. Heard with the rebuttal witnesses. We haven't seen a lot of rebuttal witnesses in other cases. At the end of the day yesterday, the court said that they were going to finish the last witness on the stand, who is firefighter Katie McLaughlin, and then they are going to leave and go on the jury view. The court is just coming back into court, but we're going to do a quick summary of where we're at so far. And I'm going to ask you to do a little thought experiment with me, whether you're watching live or on the replay crew. It's day 4. It feels like we've been in this trial for 85 years. Ask yourself what you remember, and if you want to put it in the chat or the comments, awesome. Ask yourself what you remember from opening statement and put yourself in the shoes of the jury. We have gotten to discuss this case as it's going on. I've gotten to give you my thoughts on the questions, what the objections mean or might mean, since they just say objection and there's no grounds. I've been trying to help contextualize the case and explain it. The jury has no narrator. The jury can't discuss the case with anyone. I know other people deal with memory differently, but I need to discuss things to remember them. And I don't know if I could sit here in this case and remember anything that's been said without discussing it at this point. And a lot of you remember the defense's theory of the case. And that is it. The defense started their opening statement with Karen Read was framed. And what I'm seeing in the chat is not statements of fact, but the line that you remember from the opening statement. We are 9 witnesses into the prosecution's case. Ask yourself what you know about this case. It was snowing. There was a blizzard. There is some discussion about how much snow. A lot of paramedics showed up. But what I took away this morning as I was trying to move my body, since I'm sitting here for such long days, is the thing that is standing out to me right now is that the prosecutor called the first 2 officers on scene, called the victim's brother and sister-in-law, and all of the fire medics that responded on scene. But because their opening was very in the weeds, we don't know what their theory is. We're not clear on how all of this went down. And my key takeaway from the beginning of Katie McLaughlin's testimony yesterday is that law enforcement heard, according to her, Karen Read say, I hit him. And there is a fallen police officer in the yard, in the snow. How do we know that? Because the first witness testified and we heard it on the dash cam. Does he do drugs? And they're like, no, he's a police officer. So what does law enforcement know as the ambulance is pulling away? Someone has supposedly said, I hit him. They know that he is hypothermic, that his eyes are fixed and dilated, and that the person who said, I hit him, is allowed to leave the scene, because we know she leaves. They don't call out, it seems, a crime scene investigative unit, because we're still dealing with those 2 pictures that are terrible. They don't tape off the area. At this point, My biggest question is, when is someone going to treat this like a snowstorm? Like a crime scene with a snowstorm? When? So what's happening today is we're going to finish the witness that was on the stand yesterday, Katie McLaughlin, direct examination, cross-examination, redirect. Then the jury is going to leave and go on a jury view. The jury is going to go to the home. They're not going to go into the home. Law enforcement never did. They're going to go to the street and the home and get a layout for where everything is. Hopefully, the new owners of the home left the flagpole up. I'm sure the fire hydrant is still there, so it can give them some orientation to where a driveway was, to where the street is, and so they can visualize it. And then they will be back in court at some point. If you want to make sure you know the point that we are back in court today, LawNerdApp.com. Look at these graphics, Miguelina. They're so great. LawNerdApp.com. I will notify you when we are back in court. This morning, this afternoon, I don't know. Has the court made it clear at all? No, it's not clear at all. But when we are back in court, I will notify you that we're back in court after the jury view. Will that maybe be after lunch? Maybe. Will it maybe not be after lunch? Maybe not. The communication has been delightful. So now that court is just getting ready, did I give myself a little grace period? So if we needed to zoom through the prosecutor, we could? Yeah, I did. Did I do that intentionally? Yeah, I did. Because if I have to listen to the qualification it takes to become an ambulance driver one more time, or a paramedic, or an EMT, it's all we know. It was snowing. And you retest every 2 years and everybody's certification is current. Great. I think everything else is still in question. Let's roll the intro. Law nerds, let me know where you're coming in from, what you're drinking, and if any of you heard me on the radio this fine morning. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
You know, I really try to talk about facts, not fuckery, all up in here. The facts of this case are coming in slow, and it's a challenge, but the fuckery seems to be great, which is why I'm focusing on the prosecutor saying asystole instead of asystole, because it's delightful. The defense attorney and one of the witnesses having a my cousin Vinny moment. These are the things I am clinging to because it's very hard for me to follow the prosecution's word salad questions. They're not clear. I'm sure some of you have a much easier time than I do. I am struggling to follow the questions, but the judges reminded them again and again, questions are not the evidence. The answers are. Questions are just context. But the defense has done a very good job of like dropping those seeds and letting the jury piece them together. Ask yourself as you're listening, whose side of the case is easier to piece together at this point? Are you putting the pieces together that the defense showed you? Or are you putting the puzzle pieces together that the prosecution hurled at you? You let me know as we're going. Jay Vile said, why are they doing the view so early? I don't know. I can't answer you why this court does anything. I don't know. And we don't get the little bits in the moment where everybody's talking to one another. I don't know why they do some days, half days. I don't know why they're doing the jury view the first week of trial. I don't know. But the prosecution gets to choose the order of the witnesses. And they knew the day the view was scheduled for. So they have control to choose what evidence they put in before that jury view. That's their choice. They can do that. They can do whatever they want. All right, let's fire up court this morning. Oh, I forgot Law Nerds. Law Nerds of the chat and the alternate jury of the internet. Court is now in session.
Bring the jury.
And apparently God save the Commonwealth, because that's how court starts every day. And I'm not going to lie, I love it the most. I really do. The original 13 harken back to the English tradition of law in a very different way than other states across this fine country.
For government. And
I am now thoroughly convinced that all the audio for this court feed is coming from a Zoom call. Great.
enter your participant ID. Please enter the meeting passcode followed by pound.
What is...
You have joined the meeting as an attendee and will be muted throughout the meeting.
What's happening? Maybe it's why this feed has better audio.
You are unmuted.
I don't know what's happening. Wait, why did we go back to the fan? I was so optimistic that the bailiffs had come to order. I even paused my soliloquy and now we're back to the fucking fan. There we go.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court in the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Your Honor, Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Judge David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed.
I like that they
morning,
introduce
jurors.
the parties every day.
I have to ask you those same three questions.
They've changed the order of
Were you able
seating
to
of the
follow
victim's
instructions
family
and
this morning.
refrain from
I don't know if that
discussing
means
the case
anything
with
or it's
anyone
just the way they
since you
walked
left
in.
yesterday?
I don't know.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research?
Oh, I
or
need to gain this up.
investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should.
I was talking about it on local radio. Don't listen to the radio.
Mr. Lally, I'd like to see counsel at sidebar for a brief moment.
Though I do love that the sidebar is sidebar. Like, I'm not mad. I'm not mad. Look, it harkens me back to my my youthful college days at UMass Amherst. I love it so much. All right. Well, there at sidebar, we're gonna zoom through all of this. Why do I delay when I start stream? Because of this, I would rather give you where we're at in the case than have to buy time. We're at a long sidebar, Your Honor. What are we talking about? All right, I'm gonna keep zooming because that took a minute. 5-6 minutes of sidebar. Good. Streaming is amazing. Good. Come on, feed. I believe in you, internet. Let's go. You've got this. This is the feed. This is not my internet. Let's take this down real quick and see if we can fix that and get to the beginning of this witness in a better way, which means I'm gonna have to back up to finish direct examination before they get to cross. I can't imagine they have much more on direct examination. But they were in the middle of direct examination when we left off yesterday. So now we've got to readjust the audio again. All right. Fingers crossed, folks. Streaming is dynamic. It is a joy. All right. I can hear. Hopefully y'all can hear. Now I understand what the noises are in the background. They're dialing into Zoom to get the audio, which is interesting.
Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Now, I have a few more questions for you. So,
Oh, now I can't hear literally anything.
period of time you testified about yesterday when you're at Mr. O'Keefe is in the back of the ambulance. With respect to his clothing, what, if any, observations did you make in regard to that clothing?
He had, in terms of what he was wearing.
First,
She's much easier to hear.
He was wearing jeans. He had on a dark colored light zip up jacket. And I noticed one sneaker.
Everyone has had a different take on what the victim was wearing.
That clothing, what, if
like
any,
every single
observations
witness.
did you make in regard to
Nobody said a zip up yet, so there we go with that.
It was soaked through.
That's been consistent. But what he was wearing has not been consistent at all.
Tears or holes or anything else with regard to that clothing?
Finally, we get to that question.
I didn't see any.
Any tears in his clothing? Because they all talked about the furrows or the scratches on his arm, but no tears in the clothing. No, this prosecutor's not asked a single witness that. That's interesting, isn't it?
Ms. Gilman, if I could have exhibit number 18.
I haven't even had coffee yet, and this feels slow.
Yes.
Speaking of not having coffee yet, Dr. B to the rescue.
Look at that for timing.
Look at that for timing.
Like we almost planned it that way.
You're the best. It is like we planned it, though we didn't.
Now, first, Firefighter McLaughlin, do you recognize what's up on the screen as exhibit 18?
Do I recognize,
What it is?
what it is?
Yes.
Yes.
And what do you recognize it to be?
The address of the call, 34.
Dr. B says hi.
Now, with respect to this photograph, do you observe within it or where Mr. O'Keefe was on the ground when you first arrived?
From this angle, no, I don't.
And if you could, it was not on the photograph. Is it off to the left, the right, or where would it be in relation to this photograph?
To the left, I would say.
And about how far off frame do you believe it was?
I'm not sure.
Why is there not a photo of where he actually was?
My view of the call was, my reference point wasn't a house on either side. The patient was
and I can't
off
see
the road.
Houses.
So my view of this call was the patient was on the side of the road. The only thing that I noted was a fire hydrant. So in relation to, I know it was to the left of a house, but I'm not sure exactly how far left it would be from this picture, from this angle.
Miss E, I don't know why they're showing it where
Yes.
they can't see it. I worry it's because it's the only photo they have of that house because nobody treated it like a crime scene. No further questions.
All right, cross-examination.
Well, that was fast. Okay, we're just. But others have said I can't see exactly where he was too. It was over by the fire hydrant, so I'm not surprised.
Morning.
You responded to the call
Can I move me to
of
the
an
other side of the
unresponsive
screen?
male in snow at 34 Fairview. That was the
Thank you,
address of the
Streamyard.
call.
Correct.
The house you just looked at, that is in fact 34 Fairview.
There we go. How easy is it to move my layouts? Oh, Dr. B.
As Mr. O'Keefe was being transported by ambulance, you were instructed by firefighter Flamati to get information about the victim from Karen Reed, correct?
He wasn't being transported by the ambulance at that time. He was on the stretcher. And Tony, who was at the head of the stretcher, asked me to get information from Miss Reed about the patient, but he wasn't being transported in the ambulance at that
That's
time.
a very helpful clarification.
Firefighter Flamati.
Got it.
My cousin Vinny.
When you did, in fact, did you follow those directives?
I did.
When you finally approached Miss
That's a helpful
Reed
clarification.
in order to get that medical history as best
You know who the fuck didn't clarify it though? Chat? The prosecutors. What they just clarified is whether or not Flamati could have heard Karen Reed talking to this witness because the defense asked the question, not the prosecution. And she said he wasn't in the back. Oh, cousin Vinny was not all. That's right. So this is different because Flamani was the other one. Thank you, chat. But same to the clarification, because he was asking, could you have heard this and this and that? It's helpful to know she was asking those questions before everybody's in the back of the ambulance. But those things shouldn't be clarified by the defense. What shouldn't the prosecution be clarifying some of these timing? I'm so confused. It's just
What did the scene look like? Who was with you?
Can we just
around you?
Stay on the witness?
So they started to move the stretcher towards the ambulance. Miss Reed was sort of, I guess I would describe it as moving around the scene. So she was moving, kind of going in circles. So
we saw that.
I was really just focused on her, trying to get her to converse with me and get those questions. So that I wasn't really noticing anything else at that point. I was more just trying to contact her, and she was moving around.
What were you wearing at the time?
I had my like winter fire jacket on.
What color is it?
It's yellow and red.
Bright yellow for safety purposes.
Yes.
When you began your actual questioning, once everybody sort of stood still.
I don't think they were standing still. I think she was following Reed around this scene.
You were standing in one spot. Miss Reed was standing to your right.
Oh, on the video at the back of the...
Well, the questioning started, as I said, she was moving around the scene. So the questioning was ongoing as she was moving around to different locations. I don't know exactly how many of the questions I got out during the time that she was moving around. At one point, we did come to a stop. And at that point, she was to my right.
That's the point I want to focus your attention on. When you came to a stop, that's the point at which you recall the statement being made that you attribute to my client.
Yes.
Okay. And in that group,
he's still trying to nail down who could have heard it.
I want to make sure I understand this exactly.
So do I.
So there was Miss Reed to my right. There was a civilian woman to my left. There was a police officer who was not directly across from me, but I would say maybe diagonal to me, closer to Miss Reed.
Your Honor, I'm holding a photograph. This has been shown to the Commonwealth. May I approach?
This is probably the sweatshirt. They haven't gotten this. They haven't admitted this into evidence yet because nobody's recognized it.
Off of a still photograph.
Elisa, yes. They're trying to ask her if she remembers this.
Look up after you've studied it for
And
a second.
if she does, then they might be able to admit it as what the victim was wearing. If they don't, they're going to have to use a different witness for it.
I recognize people in it.
May I publish, Your Honor?
That is not the shirt.
Yes. Is this an exhibit, or are you moving to introduce it?
I'm moving to introduce it. It has not been introduced as yet.
Okay. So go ahead and have the witness adopt it first.
Sure.
The civilian witness is one of the friends.
Closest to frame. Closest to the camera.
Yes.
In what appears to be a yellow and red jacket.
Yes.
Who's that?
That would be me.
Who's to your right?
It appears to be Miss Reed.
And to your left?
A civilian woman.
And across, as you said, sort of diagonal, closer to Miss Reed is?
A police officer.
Do you know that officer's name, by the way?
I don't know his name.
So the question is going to be,
Your Honor, with that, I would ask that this be marked as
who else was still
is
there when
any
you were
objection?
talking to
No
Karen
objection.
Reed?
So we are going to remark these exhibits today because of the problems that I indicated at sidebar.
Well, now we know what sidebar was about.
How do you want to do this, Madam Reporter? I don't know.
This is a
where we
still
start
from the video. So this is a still from the video.
Tori, how many are in evidence?
And the court is asking her court staff because they had pre-marked evidence, and it seems that there was some confusion. It sounds.
Folks, it's my responsibility to make sure the record is intact. And you've heard numbers 1, 3, 309,
And now it's a cluster.
247. We need to straighten this out to make sure it's appropriate for you. You know what, Madam Clerk, just mark, Madam Court Reporter, just mark it as the next exhibit
Mock it.
number, whatever in the hundreds
And
that
then
is, and we'll
send
take
it.
care of this today. I don't want to waste your time, folks, while we do this, but it's very important that we do it.
PJ asked, why are the EMTs on trial? The first responders so far, the only ones that have testified to hearing Karen Reed say things like, I hit him. That is a huge key to the prosecution's case, because they have raised this from an accidental, driving under the influence, hitting someone, causing death, to a volitional or intentional homicide. So they have to prove that she intended this if she did it. And they have to prove how she did it. But they have to prove that she intended to do it. So the EMTs and the fire medics being the only ones who heard those statements, he's trying to prove, look, they couldn't have heard these things. The one younger guy never heard I hit him, heard, is he dead? Is he fucking dead? Somebody else heard Karen Reed purportedly say he didn't come home. So this is where the statements matter, and where if those statements happened when this photo happened, none of the other firefighters are around. So did they hear them while they are inside the ambulance? And could they make it out? Because it's hard to make out what she's saying from the dash cam. So that's what they're trying to do.
All right.
Good question. I thought it was worth pausing to talk about it.
All right. So there was any objection to that from the Commonwealth?
No, Your Honor.
Okay.
Yes.
No, Your Honor. They already put the
McLaughlin,
video in evidence.
This is the time or the scene that you told us about when you heard the statement that you've attributed to my client, correct?
Sorry, say that again?
Sure. This is a moment in time. It captures a moment in time when you're standing there. To your right is Karen Reed, which you've described. To your left is a civilian female, which you've described. And across from you is an officer, which you've also described.
Yes.
So this would be the time, or close in time to the time, that you heard the statement.
So where is everybody else?
Correct?
Yes.
The first time you ever made that official report, or an official report to law enforcement regarding that statement.
So where's everybody
was
else?
January 30th, 2022, correct?
Well,
Ma'am, that is a yes or
yes
no
and no.
question.
The statement was made
really
in
have it
front
both
of
ways.
the police officer, so that would technically be the first time that statement was made to a police officer in my presence. And then, yes, I testified to it on January 30th.
Is that statement in his report?
You said it on January 30th. You weren't testifying under oath, correct?
Okay. Said it.
She's like, yeah,
Yes.
whatever.
My question was really, and I appreciate you clarifying, my question was really the first time you actually told this statement to any law enforcement officer was on January 30th.
Yes.
Okay, we can take that down.
And she testified, look,
That was when you met with
police were standing there. That's their job.
Yes.
Obviously, that was very close in time to the event. It was the next day. Is that right?
Yes.
The events were close.
The 29th. Yeah. So it would be the next day.
Right, 29th, 30th.
Yeah.
Okay. The events were fresh in your mind at that time?
Yes.
You obviously knew about the importance of that interview. You knew that it dealt with a police officer who had passed?
I knew it was important to talk to the police about what I heard.
And you wanted to be accurate?
Yes.
You wanted to be as detailed as you possibly could?
Yes.
And you understand that memories, obviously, they get a little worse with time, not better with time, right?
Sure.
The closer in time you are to the event, the fresher your memory is going to be about the details of that event. You would agree with that, right?
Sure.
You told Trooper Proctor.
Sure is
the
not
day
really a
after
yes
the
or a
event,
no, but okay.
On January 30th, that the statement that you attribute to my client was actually made to the female, not to you in response to your questioning. That's what you told Trooper Proctor, correct?
I don't have those notes in front of me,
I don't
so
remember what I said.
I don't know that I can tell you that that's correct, but the statement was made in response to my question. However, the Miss Reed was looking at the civilian woman as she said that.
That's an important distinction.
Refresh your recollection that what
Don't read what you think refreshes a recollection. You can show or you cannot read it. Yes.
take a look at the highlighted portion of that report.
That's appropriate for the judge. The judges in some of the other cases we've watched haven't shut that down.
Okay.
That's appropriate.
Sure.
Yes.
Because if the witness doesn't remember saying it, the shit's out of the horse.
Does that refresh your recollection about what you told Trooper Proctor on January 30th?
Yes.
And you told Trooper Proctor,
Don't
quote,
let her.
in terms
Hold on. I'll see it side.
Okay. Alrighty. The witness needs to be the one to testify, not the lawyers. Though on cross-examination, that feels a little bit more like the lawyers are the ones who testify. We are going to zoom.
Yes.
In fact, what you told Trooper Proctor was, quote, Karen then turned to her friend and stated, I hit him.
And he won the sidebar, clearly.
Correct?
Okay.
Is that yes?
Yes. If you're saying that's in quotation marks in the in that, then yes.
That's what's in the report.
Okay.
And you don't have to agree with me. I'm asking yes or no questions.
She just saw the report.
Thank you. So in fact, what you told Trooper Proctor was that Karen Reed looked at the female to your left and said 4 times, I hit him. Correct?
Yes.
And have you since learned the name or identity of the female that was standing to your left?
No.
You're aware that the female that was standing to your left reported the exact same statement?
No.
Are you aware that the female standing to your left reported that exact same statement as, could I have hit him? Did I hit him?
No, I'm not aware of that.
Those are good questions.
You then went back to the ambulance.
Because it gives different context.
You believed you heard my client say.
Yes.
You opened the ambulance door, correct?
Yes.
That was the back door?
The side door.
The prosecution didn't ask that.
And there were two firefighter paramedics in that ambulance at the time, correct?
I believe there were more than 2 at that time.
2 of them included firefighter Nuttall and firefighter Flamani.
Yes.
And at that point, you told them what you believed you had just heard.
So I went into the back of the ambulance. I said,
she said, open the side door.
This is his date of birth. She says he doesn't have any medical history or allergies, doesn't take daily medications. And then I said, she's saying I hit him. And firefighter Nuttall motioned to his face and said something.
Ask another question.
So the answer to my question is...
Wait, did Alan just object to his own answer?
In front of Flamati and Nuttall, the phrase, I hit him.
Yes.
She said it in front of them. Not Karen Reed is what he's eliciting now.
I don't write a report in this scenario of my job.
Let her finish the answer, please.
So there are 2 people that will write reports in my department on a call, one being the lead paramedic and the other being the officer who's on scene. So those are the people that write reports, and I was neither of those, so I did not write that in a report.
Okay.
That's correct.
So let me ask the question again. You didn't write it in any report?
No.
You didn't write it in any...
I don't know if Nuttall and Flametti lied, but I don't know if they lied or if they're remembering her saying it, not Karen Reed saying it. I'm not sure, but none of them wrote it in their report. So either way, they didn't think it was all that important. And it might be because of what Posse Wazzy Leonard said. I hit him versus I hit him. And that's what the defense is going to focus on. When asked what happened, did she turn to her friend and say, I hit him? I hit him? So now is this a did I hit him or her affirmatively stating I hit him? But if this statement is what the prosecution is hinging their case on, this is not good for them at all. because there is a lot of this. This is not a clear statement. And when there is doubt, doubt goes to the defendant. But this is not clear of her saying affirmatively, I did a thing versus what happened. And the prosecution has not made it clear that this is an affirmative statement of I did a thing. The defense has made it very clear that there's a lot of confusion over how she was saying it, what she was saying it, and who heard it and who they heard it from. And the other paramedics might be remembering her saying it and be confusing the female voices. That's possible, that they remembered hearing it. But the holes are being poked, and this statement is not clear. I think that's what I'm left with at the moment. But I don't necessarily take away that somebody lied. I don't know if they remember it the way they... I don't know. When you're running a code, how much you're going to remember is another thing. And if they don't have anything more clear than this, then I don't know how much weight the statement holds. The jury gets to decide how much weight the statement holds.
No.
You didn't document that statement in any way whatsoever, correct?
Other than my interview.
Last thought. Law enforcement is standing there when it's said. Aside from what all the ambulance, firemedics do, the action of the police officer on scene is more instructive to me. What did the officer do? Did the officer treat it as if she was saying, I hit him? Did they mark it like a crime scene? Did they start taking photos? Did they keep Karen Reed at the scene and not let her leave? What did law enforcement do with the statement? Because I think that gives us more weight on how they treated it than how the paramedics treated it at this point for me.
With Proctor and my subsequent testimony.
So
you didn't document that statement in any way yourself, did you?
No.
Yeah, my cousin Minnie is going to come into this case a lot.
In that conversation that we just talked about with Proctor.
If y'all haven't watched My Cousin Vinny, this weekend is the weekend.
Evolved. Is that right?
Your statement has evolved, is what he said.
I don't know how to answer that.
You testified yesterday to something quite different.
Not quite different.
Than what you testified, I'm sorry, than what you stated to Trooper Proctor.
Respectfully, I think my testimony has been pretty consistent.
You testified to something yesterday quite different in context than what you told Trooper Proctor. Isn't that right?
I don't know that that's right.
Well, you told Trooper Proctor, Karen Reed looked at a female standing to your left, said, I hit him, I hit him, I hit him, I hit him. Right?
Yes.
Yesterday, you told these jurors that Karen Reed said, I hit him, and an officer said, you what? And she repeated, I hit him, and the officer immediately turned and went to find another sergeant.
So, ma'am, do you see the difference there?
Is that right or no? Yes or no?
No, there was more to that testimony.
That's not what you said yesterday?
I think I said more than that, than what you just repeated.
Is what I said consistent with what you said yesterday? There's a lot of things that you said. More. I'm asking, is that the sum and substance of what you told these jurors yesterday?
And she's saying
yes.
no.
So you would agree
that
she
from
said that time till yesterday,
now I'm confused.
Your story has evolved. It's changed.
Would I agree with that?
She's like,
I don't know that I agree with that.
You think the story that you told Trooper Proctor is
We're going to get an asked and
I
answered
understand
objection.
what you're saying. So I understand what you're saying.
So has your story evolved?
Okay. Yes.
Okay.
Oh, okay. It's interesting that when pushed, all the witnesses back down and go, yeah, okay, fine. It's a murder trial. Yeah, okay,
I went to high
fine.
school with somebody named Caitlin Albert.
With somebody named Caitlin Albert.
Who are you friends with, ma'am? Ma'am, who are you friend?
Would I agree with that? I don't know that I agree with that.
The defense is not backing down.
The story that you told Trooper Proctor is exactly the same.
I understand what you're saying. So I understand what you're saying.
So has your story evolved?
Okay. Yes.
Okay. Ms. McLaughlin, Who's Caitlin Albert?
I went to high school with somebody named Caitlin Albert.
Somebody named Caitlin Albert.
I went to high school with
Wasn't it
somebody
the
named
Albert's
Caitlin Albert.
house? Isn't that the
Do you know Caitlin Albert?
crime scene?
I do.
You're friends with Caitlin Albert?
She's trying to distance herself.
I
I went to high school with someone is a whole lot different than I'm friends with, by the way.
would say more acquaintances.
You're going to catch some
not close
defense
friends.
smoke in a minute, it feels like.
I would say that
Thanks,
we
Dr. B.
have mutual friends, so we might see each other occasionally because of mutual friends, but we don't have a one-on-one friendship or hang out regularly.
Who's her dad?
I don't know.
The objection system.
Do you know who her family is?
Objection.
Sustained.
What?
Yes.
Yeah, you better approach. How? What? Why? I understand why they're objecting, but objection, we don't like this testimony is not a valid objection. If the prosecution knew this was coming, why are you not bringing it out on cross? Why are you letting your witness hang out there and twist? Like, what is the prosecutor doing? Oh, ask your witnesses. Ask your witnesses the questions that are going to look bad if the defense is the first one who mentions it. Why is everyone standing up? What is happening in this court? Are they taking a break? Everyone is standing up. Why is everyone standing up? We have no audio. What is happening? I need to know who this journalist is because this journalist seems to be sponsored by Prime at this point. This is like the third day in a row. I've got so many questions. I want to know. Please don't internet. Please don't. Please don't go find who this journalist is. It's rhetorical. You guys were so helpful though when we were talking about how delightfully dressed Chanley Painter was every day in court. You're like, that's Chanley Painter. I'm like, she looks gorgeous. I'm just kind of curious. Okay, so the audio's muted again and everybody's standing up. What the fuck is happening and why don't we, are they excusing the jurors? I imagine they're sending the jurors out. I try to give helpful legal commentary, but that's not possible when I don't know what the fuck is going on in this courtroom right now. I'm imagining they're letting the jury out. But no, the defense attorneys do not look thrilled. I'm now literally relying on the closed questioning.
Miss McLaughlin, I'm going to let you step out for a few minutes.
They're going to argue this on the record.
Show them what you have and let a court officer know when you're ready for me to come back out.
All rise for the court, please.
Oh, there's much more to this, and the prosecution and the defense are conversing about it. However, when I was a prosecutor for 10 years plus, when you know stuff that is unflattering about a witness, sus potentially, or that looks bad, you ask it in advance to let the witness explain and contextualize. Because on cross, it is going to be direct question, yes, no answer, and it's going to be very tight and it's going to look less than flattering. That's their job. But the prosecution has to do their job. Or the prosecution's like, fuck it, you're on your own, man. Good luck. And maybe that's why. Everybody's saying, why can't we listen? I don't know. I don't know. Let's zoom and see where we get on this, because we've got a lot of time. We've got a lot of time stacked, and We had stacks of time this morning. Not an experience I'm used to, being very ADHD. Oh, well, that looks like they're not back in court just yet. Let's see. Nope. Are we just still only fan? Only fan. Well, this is turning out to be a much spicier morning than I anticipated. I'm like, okay, they're just going to finish up this witness and then like potato. Not at all. All right, I'm going to answer some questions. I'm going to just kill the fan. We're going to just kill the fan. That's interesting. That's interesting. So for those of you asking here, let me try to contextualize what just happened. Given the very little information we have, in the middle of cross-examination, the defense started to ask about Caitlin Albert. I am going to presume, because we don't know and it's not in evidence, chat might have greater knowledge, but the jury doesn't know, and we don't know. I am going to presume that because the crime scene, and yes, I'm calling it the crime scene, is the Albert's house, that Caitlin Albert is somehow connected to the same Albert family at the house. Otherwise, it's not relevant at all. So for it to be relevant, it has to be connected to the location. Ooh, I hear noise. It has to be connected to the location in some way. The defense was showing things to the prosecution that they have not seen yet. The defense is allowed to bring things in to impeach witnesses. This could be evidence of the acquaintanceship between Caitlin Albert in this witness. We're going to see what that is. But the impeachment does not have to be given to the prosecution in advance. However, the prosecution should have known all of this. It's a small community. You have to know who knows everybody. So for those of you asking, social media posts, maybe. But the prosecution has to know that in advance. The defense opening statement was the Alberts are a well-connected family. That is their theory of the case. So if you have the person who heard the statement and relayed the statement to everyone else connected to the family, don't you think you need to know that? We're going to find out right now, aren't we?
All right. So, Mr. Jackson, let's mark for identification the items that you told us about at sidebar.
First in order would be do you want me to describe them for the record, Your Honor?
No.
Yeah.
So they're not to be put up on the screen.
These are 4 items.
They do look like social media posts.
So don't.
The jury, we're sitting in the jury box, essentially. Is that a friends list and photos?
These are 4 items. One of them.
Alan, flip through them.
Don't describe them. I need to see them. So let's bring them up, mark them for identification, Madam Clerk. Then I'll get them back. But I need these marked for identification. And I need to see them.
The internet demands, Alan, that you flip through them. Alan! Excuse me, Alan, I'm going to need you to flip through those so we could... Ooh, clerk. The clerk could do it. If you keep handing them over that way, we'll be able to see them.
All right.
Even George is fascinated. He's like, what are we doing? Why is the judge going to the rules of evidence? What is your notebook? Oh, no, that looks like the evidence notebook. They're marking them. I don't know if the jury's going to get to see them. We'll see when the jury gets to see them or not. We don't get to see them till the jury gets to see them. However,
thank you.
The camera is sitting where the jury box is, maybe a little higher up, because the jury box is on the opposite side of the audience. So the audience up here is opposite the jury. So from that vantage point, maybe the back row can see.
Mr. Clerk.
I'm so curious. And this, chat, is why I wanted to go into this case without going to the internet to learn all these things. I want to see them as they unfold in court. I want to see how they unfold in court.
Okay, so we have 4
What?
Marked 4 pieces of paper marked for identification.
She's not even going to say what they are.
You got these off of social media sites, Mr. Jackson?
That's correct.
Okay. When did you get these?
I don't think the jury's back.
I couldn't tell you the exact date.
The jury's not back. Oh, now they're going to have to authenticate them. The jury's not back. Otherwise, the camera wouldn't be panning in this way. So they are going to be arguing over whether or not these are coming in as impeachment. Spicy.
Between 6 months and a year.
All right. And Commonwealth, you've not seen these before?
No, Your Honor.
They're impeachment. They don't have to.
So we'll talk about Rule 14 in a little bit, but we'll bring the witness in. You can ask her questions, Mr. Jackson, about her vacation that you mentioned, the drinking that you talked about, the relationship with.
There's a
Ms.
vacation?
Albert. I've forgotten the first name already.
Caitlin.
And Caitlin, and about the house. So you can ask her questions about that. And let's see, you can show her these exhibits or these marked for identification.
So 6 months, I saw the question here. So 6 months to a year in the Commonwealth haven't seen them, sus. And I'm not calling it out. I'm just wanting to explain. If they're on social media, the prosecution has access to them, and the defense does not have to turn over impeachment items for the witnesses. They're not required to. So the state has access to this witness and should have asked this witness what she knows. It's not like it's a secret that this is a small community and everyone and their mom and them went to high school together. This would be like prosecuting something in Manhattan Beach. Everyone knows everyone and their parents. Half of you know communities like this where everybody grew up, and your kid's elementary school teacher is somebody you went to high school with, and your kid ends up being besties with your ex-boyfriend from high school's nephew. That's how these things work. Is that just my life? I mean, we moved, but is that just my life? This is how small communities work. Suburbs of large cities have interconnectedness like we saw in Murdaugh, where everybody went to high school with the Murdaugh. Same. Are the Alberts the Murdaughs? Same.
If you need to. You may have trouble actually getting those into evidence, but I'm going to let you find out. You can ask her to identify them, how long ago they were, things like that.
Thank you.
You may have trouble.
All right, could we bring in
the judge is like, you may have trouble getting them into evidence.
Ms. McLaughlin, please. Yes.
Their impeachment. Someone I went to high
you just
school
saw
with.
these today. I'm sorry, I don't remember if I asked you that.
Yes, and yes.
And you were objecting that you objected to sidebar that these come in at all?
Correct.
Okay. Oh, here's the fourth one. I'm sorry.
Someone
Mr.
I went
Jackson,
to high school with.
the last
someone I went to high school with and someone you're vacationing with might be the same, but the insinuation and implication is very different. I have vacationed with people I went to high school with. They're my very close friends. I'm sorry to all you other fuckers I wouldn't vacation with. Except for the ones that were really mean to me. Sorry, not sorry. Diane, my husband grew up in Kern. I know exactly what you're talking about. So anyway. Some of you know this
So,
world.
Ms. McLaughlin, Mr. Jackson's going to be allowed to ask you questions outside the presence of the jury.
Oh,
and
we're
you're still under oath and you have to answer them truthfully, okay?
We're going to voir dire on it. Okay, ladies and gentlemen of the Law Nerd Chat. This morning has gotten spicy. I love a good voir dire. The last time we saw a voir dire on impeachment and witnesses was rebuttal witnesses and Depp v. Heard. We're going to voir dire on the witness to see if this will be allowed to come in before the jury. The jury is out of the room. So they are voir diring on the impeachment outside the presence of the jury. Why? Because you can't put the shit back in the horse if the jury hears it. Oh, spicy morning. Ma'am, who you friends with? The chat has questions. So this is the first witness where the tea is actually scorching.
When, just briefly as a predicate, when you stepped out, I just want to make sure we're...
Oh, he's going to tell us everything that just happened. I'm turning this back up a little bit because I can't hear Alan very well. Oh, the prosecution should have known this was coming. It's not like Facebook is a fucking secret.
Very clear. Did you have a conversation with anybody from the Commonwealth between the time you walked out of court and just now?
Just about if I needed a drink of water or to use the restroom.
Okay, but nothing about the substance of your testimony.
No.
Good.
Ms. McLaughlin, I asked you before we broke if you know who Caitlin Albert is.
Yes.
You said that you went to high school with somebody by that name, correct?
Yes. You
in fact know that person as a friend, correct?
I know her.
She's more than an acquaintance.
I would say she's an acquaintance. She's not a close friend.
Is she in a group of friends of yours?
We have mutual friends.
How long have you known her?
Since high school.
Probably since
elementary school?
Since high school.
When you say, I don't want to ask your age. I wouldn't do that. How many years? How long of a span of years?
Alan, she's a young woman. It's fine.
Since high school, so maybe 10.
And you know her family, generally?
I don't.
You don't know anything about her family?
I don't know her family.
Had you ever been to her house?
Not that I recall ever being there.
Not that you recall, or you haven't? Those are two different things.
I don't recall ever being there.
Okay, so you might have been there, you just don't recall.
I don't recall ever being there.
Okay. If I were to ask you if you have ever been to her house, yes or no, you cannot answer that because you don't know.
She does not know.
You cannot recall, correct?
High school is a long time ago, sir. She's not sure if she has.
I would say, I mean, I
don't know is the
towards
answer.
no. I have no recollection of ever being at her house.
Is there a picture? If there's not a picture of a party, then this is all going to go by the wayside.
Media?
Yes.
May I approach you on that?
Yes.
But your friends on social media.
All four of these up here. I know what they look like. Can you do me a favor and take a look at the first document? What does that document appear to be?
It says Caitlin's friends.
What does it look like? That's a printout of.
I'm sorry?
What does that look like? It's a printout of. Does that look like it's from Facebook or one of the social media apps?
Yeah, I don't know exactly.
She's like, I don't know which one.
Some social media.
Okay. Under Caitlin's friends, do you see your handle, for lack of a better phrase?
I do.
I mean,
is that you?
Yes.
If it's Facebook, though, photograph. Like the amount of people that I was Facebook friends with before I got rid of Facebook was a lot.
Before we talk about that next photograph, which is, I should go in order for the record, Your Honor. The first one was H.
But what is it?
Before we talk about I, which is the next photograph, how long have you been social media friends, quote, friends with Caitlin Albert?
I don't know.
More than 5 years?
I mean, high school.
More
Probably.
than 8 years?
I don't know.
Chad, I see that you guys have more
The
evidence
second photograph,
in
or the
evidence
second
of the chat than I
appears to
do.
be a photograph. It's I. Is that right?
But
yes,
it's not an evidence for us.
Do you see yourself in that photograph?
I do.
You see Caitlin?
Okay, to clarify, my work has Facebook. The Emily D. Baker is on Facebook. My personal Facebook is not on Facebook because people on the interwebs are trying to find like my family, and I didn't want them to get hassled by the internet. So my work Facebook, my public Facebook is on Facebook, but my personal Facebook isn't on Facebook, which, you know, was high school friends, family, my cousins. Like the internet doesn't need all of that. So that. But I'm curious as to what she's looking at.
I do.
When was that photograph taken?
I have no idea.
Where was that photograph taken?
I don't know.
You have no idea how long ago that was?
I don't.
What was the event that was depicted, or that is depicted in that photograph?
I don't
Ugly
know.
Planet. It wasn't this chat.
Is that local, or was that on a trip somewhere?
She doesn't know the
I
photo.
don't know.
There's not
Probably
going to be foundation
local.
for
If
it.
it's a beach, I don't remember. I've never been away like to a beach on vacation with all of these people, so probably local.
When we say local, let's talk about local. I don't mean we may have different definitions.
The Cape.
Where would that be? What beach? I'm not as familiar with the location.
I'm not sure.
Maybe on the Cape?
Possibly.
Do you recognize some of the other folks in that photograph?
I do.
Matter of fact, there's a lot of people in that photograph, right?
There's a lot of people in it.
Did you take a trip with all those people at some point in the past?
I mean, a beach day and a trip are different.
Take a trip.
To the beach.
Did I go to the beach at some point?
Alan, you do realize Boston is like on water, right?
With these people, yes.
Okay. When did you go to the beach with all those folks?
I don't know.
A trip to
I
the
don't
beach
know
is
when
different.
this picture is from.
Have you
It
gone?
seems old to me, but
Well, you can see yourself. I mean,
yeah.
What was that? Did you say it seems old to you?
Yeah, to me.
Okay.
This isn't like a recent to me.
how old do you think that photograph is?
I don't know. It could be around high school. I'm not sure.
And I know Mr. Jackson didn't want to ask you how old you are. When did you get out of high school?
2014.
Okay.
I graduated.
So could that
Ma'am.
have been around 2014?
It could be.
So you've known Caitlin for at least that long.
Yeah.
And when I say travel, I mean travel outside of Canton. Gone places with her, correct?
Yes.
You've posed for photographs with her,
Yes.
with other folks.
Yes.
It's like socializing and partying, correct?
She's
Looks
not
like
going to
socializing.
answer. She's not going to
Maybe it's
answer
on
that.
vacation.
That's not a
I've
vacation,
never been on
Alan.
vacation with a big group of people like this.
Well, that doesn't look like a. What would you call that if that's not like a mini vacation?
Okay, Alan, she called it a beach day. Stop trying to make fetch happen. It might have been a beach day. If he only pulled this off of social and doesn't have everything to back it up, it's going to be a problem because this might not come in if he can't lay the foundation for it. And she's like, I don't know. But yes, this could have been a senior beach day after prom. There's a lot of things it could be, but if this witness doesn't know that, then they're going to have another witness to impeach her. In chat, you guys are like, she's lying. That might be, but the jury's not going to hear this unless there's foundation for it because there's process.
Day at the beach?
A day at the beach. Okay, so maybe a day vacation.
Sure.
That's not a vacation, Alan. Stop trying to
Well,
make
that's
fetch happen. Have you never had a
Jay.
senior ditch day, my dude?
May I approach, Your Honor?
Yes.
I do need to remind myself.
Look,
That photograph looks a little older, correct?
saying that they are acquaintances and saying that they went on vacation together is different. Pushing the fact is not going to help. You have the picture. Stop pushing.
They both look old to me. I don't know when they're from.
Sometime in the last 10 years.
Questions about that?
Presumably.
These are trick questions. I don't want to waste your time. What's that from?
It's not a vacation.
I don't remember specifically what or where this is.
Do you see yourself in that photograph?
I do.
You see Caitlin in that photograph?
I do.
Does
You're
he
all
have
posing
the
for
metadata
camera,
dates?
correct?
Yes.
What's the location?
I don't know.
No idea.
I don't.
This is yet another socializing event with Caitlin that you can't recall.
I don't know where this is.
Is it just
exactly?
Caitlin?
I'm sorry, I didn't mean to step on your words. Go ahead.
I don't know where this is exactly.
So you've had so many.
He's going to get into an interesting question, but chat, I don't think these are pulled off of her Facebook. And that is probably what some of the problem is here. That if these are not on her Facebook, she's like, I don't know what that photo is. We'll see if they get the foundation for it.
Socializing events with Caitlin
He was getting to, so you spend so much time together, you can't remember the dates?
that you can't recall.
No.
I don't know where this is
that
exactly.
I'm sorry, I didn't mean to step on your words. Go ahead.
I don't know where this is exactly.
So you've had so many socializing events with Caitlin and other folks that you can't pinpoint this one as opposed to any of the others that you've had.
No, I'm saying I can't. These photos are old. I don't know. I don't remember where these were or the circumstances around them. That's what I'm saying.
You see how you're dressed in that photo?
Yes.
You see how you see the other friends that are there with you?
Yeah.
How many people would you estimate are in that photo?
Do you want me to count how many people?
Give me it. I don't have the photo in front of me, so just give me it. Is it more than 5?
12?
12 people.
Ish.
Do you recognize those dozen people?
I do.
Did you go on a day trip with those dozen people?
Yeah, possibly.
When?
She's like, I'm in a
I
picture.
don't know.
Where?
I'm sorry. I don't know. I don't remember.
How many times have you gone on day trips with those dozen people?
I don't know.
Sir, ask if it was a clam bake.
Turning back to photograph I, how many times have you gone on day trips and socialized with those number of people? It looks like probably double that, 20 or 25 people.
I don't know.
That's a big group of friends of yours that includes Caitlin Albert, right?
She said they had mutuals.
A big group of mutual friends.
So it's not just that she's a mutual friend, she's a friend. Isn't that right?
As I said before, I would consider myself more of an acquaintance. We have mutual friends. I wouldn't consider her a close friend, but yeah, I mean, that would be my answer.
She's basically saying we run in the same circles.
I didn't grow up with her. I went to high school with her.
When I say grow up with her, I mean you grew up in the same town as her, right?
Grew up in the same town.
Went to the same high school as she did.
Yes.
Socialized with the same friends as she did.
How many people are at the high school?
Went on day trips with her.
Yeah. Apparently.
Yes.
And have all the same friend group.
That's not what she said.
I don't know that we have all the same friend group. These are people that we're both friends with.
But you don't consider her anything more than just an acquaintance.
Yeah, that's what she said.
I think I described it to you.
The answer to my question is you don't consider her to be anything more than an acquaintance.
I wouldn't consider her to be a close friend.
Now let's take a look at the last.
Those answers are kind of evasive. Is she an acquaintance? Is she not an acquaintance? Do you have mutuals? Do you not have mutuals? But the defense is going to keep pushing. This is outside of the presence of the jury. They're allowed to keep pushing. But the defense has a lot of like, they're there in this case. And if you try to make the things that maybe aren't super there in a small community, like, yeah, we know all the same people because we went to high school together. I don't know how many people are at their high school. In 2014, it's a lot different having a class of 300 people versus a class of 50 people versus a graduating class of 500, 700, 800, 1,000 people. So the jury will know that because this is their community. But if there's no foundation for these, they're not going to get them in. We'll see. But there's lots of issues to push on this. Over pushing doesn't always
describe what's
work.
in that photograph.
So we'll see. But she is
There's a
parsing.
It's a picture of me. Caitlin is in it, and there's seems to be other people in it as well.
May I approach?
Yes.
But the point is, do you know the person who lived there? For those of you asking in the chat, who is Caitlin? None of the lawyers have explained.
Sorry.
The last name is Albert. I'm assuming that the house where the victim was where victim Officer O'Keefe was. But that's an assumption because nobody's clarified it in court. I'm sure some of the chat actually knows this, but it's not in court yet.
I want to drop it on you. That's a close-up photograph of who?
Caitlin, and I'm also in it.
The jury's out.
You're doing what in the photograph as it relates to Caitlin?
It seems like I'm kind of kneeling down next to her.
Touching her?
Can I see that for just a minute, please?
The judge is not liking this either.
I'm sorry, can you show me you?
Can you show all of us? Okay. Did you, Alan, why didn't you bring it up for the class?
May I approach one more time, Your Honor?
Yes.
Thank you. Take a look at that one more time.
I mean, I'm going to start speculating wildly in a minute. Like they're in a group of mutuals, but you know, they're not besties in that group. I wonder if they dated the same people. And that's why they're like, we're not besties. We're in the same group. I got questions.
just behind Caitlin in that photograph?
Yes.
Caitlin was the one drinking the beer?
Yes.
You got your right arm around her?
Yes.
You both appear to be wearing swimwear,
Yes.
bathing suits,
Are these all from the same
Yes.
day, though?
and you're giving some sort of a sign with your left hand.
No, I'm not.
Is that somebody else's hand that I saw? Maybe that's Caitlin's.
Yeah.
I'm sorry, I don't have the photograph in front of me. I don't have it committed to memory.
Bring it up for the class, Alan.
Looks like that's a photograph that you and Caitlin posed for together, correct?
Is it cropped? Is it edited?
It seems like it's a close up of a bigger, like a picture.
That was my
seems to be
question.
zoomed in on a group of people.
Which was posted on social media.
Did you post
Okay.
it? Did she post it?
Are you telling me that?
I'm asking you that.
Did
You
she
ever seen that
post it?
posted on social media?
For fuck's sake.
I don't recall seeing this picture, but if it was on social media, then
No.
Okay.
Ma'am,
How long ago was that picture taken?
I don't know.
Who took the picture?
I don't know.
Where were you when the photograph was taken?
Probably at a beach with if we're wearing bathing suits.
Probably at a beach or at a beach?
she doesn't know is the thing,
Well,
Alan.
I can't see a beach in the picture.
And I
Wearing
don't
bathing
remember it.
suits, it could be at a beach.
Right. Do you recognize the bathing suit that you're wearing in the photograph?
Is it the same
No.
as in the other
You
pictures?
literally don't even recognize your own outfit?
No.
So that doesn't help define.
Alan, if I am this young woman, I am running around in 1,000 different bikinis. Seriously.
Where you were and when that photograph was taken?
No, sir.
Do any of these photographs remind you that you've been to Caitlin's house at some point in your friendship with her?
No.
Has Caitlin ever been to your house?
Not to my recollection.
When was the last time you talked to Caitlin?
I don't remember exactly. It's probably been a few years.
When was the last time you went to an event, socializing event with Caitlin?
Again, I don't remember exactly.
Did you talk to Caitlin at any point at or around, on or around January 29th, 2022?
No.
When was the last time you had talked to Caitlin before January 29th, 2022?
I don't know.
Would it have been a day before, a week before, a month before?
Sure, no.
No, I don't talk to her. Like I said, we're not like close friends, so it's like pretty infrequent that we would interact. So I don't know when the last time before that.
What about texting or Snapchatting or communicating in that way?
I don't remember.
Would it have been a week before the 29th?
I don't think so.
You don't think so, or you know so?
I don't think so.
What about after the 29th, after you responded to 34 Fairview? You ever have any communication with her?
Not that I can recall.
So is that something that you think you might remember if you responded to a house of her father where there's a police officer dead or dying on the yard, on the lawn, 30 feet from the front door?
That's the
Might have had a
question.
conversation with Caitlin?
I've never had a conversation with Caitlin about that call or this case.
Did you ever contact any of your other friends about the fact that you responded to Caitlin's parents' house?
No.
Were you ever asked about this relationship that you had with Caitlin Albert, this friendship that you had with Caitlin Albert at or near the time of the 29th of January?
No.
Did you ever disclose to anybody that you had a relationship with Caitlin Albert at or around the time of this event?
No.
When you went to 34 Fairview, you knew that that was the Albert family home, correct?
No.
When did you learn that it was the Albert? You now know that.
I know that now.
When did you find out?
I don't know. I don't recall. It was some point after. But I don't know when.
Would it have been the next day?
No.
You and firefighter Flamati and firefighter Nuttall were all discussing this case pretty intently after this event, correct?
No.
It's not that often in the little town of Canton that a police officer is found dead or dying on another police officer's lawn. Wouldn't you agree with that?
I imagine that's unusual.
We responded to a medical call, so the conversation after the fact was at the hospital, debriefing the call, going over.
No one treated it like a crime scene at that point.
What happened, what we use for equipment, what we need, and just like that was the extent of the conversation.
Would you agree that this case, given its notoriety, is discussed at the fire station almost daily?
I don't know when I'm not there, but it does get brought up.
And obviously the fact that
because of all
the
this, I'm
house
sure it
belongs
does.
to, or belonged at the time to the Albert family is part of that discussion.
I don't know. Like I said, it gets brought up, but I just avoid it. I don't engage in the conversations.
It was certainly enough of a
she's a
subject
witness.
matter that you learned, according to you, after the 29th, that house belongs to Brian Albert, Nicole Albert, parents of your friend Caitlin Albert, right?
Well, at that point, it was on the news consistently, so I don't know where that information was introduced, but
it was pretty early on after the 29th.
I don't recall when it was known that was the case.
I mean, you didn't learn that was the Albert family home last week.
No.
You've known it for going on 2.5 years.
I don't know exactly when I learned that was the house.
I realize you don't know exactly, Miss McLaughlin.
But you keep asking her.
The day you learned. I'm asking you, you've known this basically through the lifespan of this case.
That's not really what you asked.
At some point after I learned it.
Right. I'm just trying to figure out about how long after. A week after? A month after?
Before or after the grand jury?
But it was more toward January 29th than it was yesterday, correct?
Correct.
Just a moment, Your Honor.
Yes.
If he doesn't have foundation for those pictures, it's going to be an issue. Because we don't know if these came from the witness's Facebook page, if these came from someone else's Facebook page, if they came from an Instagram account. We don't know. Here's what we don't know. And Chad, I know a lot of you have more info about this case than I do. I want to see what's coming in court because that's what the jury has. And it's frustrating. It's frustrating not to know. But what social media? Whose social media? When were the photos taken?
One other question.
Is there any foundation for them?
Do you know any of Caitlin's siblings?
No.
You don't know Brian Albert Jr.?
No.
Do you know any of her extended family that might be a little closer in age to you, like Colin Albert?
No.
Have you ever met any of them?
Not that I recall.
Not that you recall, or no?
I don't remember meeting any of them.
Your Honor, that's all I have right now.
All right, Mr. Lally, any
Some
questions?
of that's not coming in.
Just a few, Your Honor.
If they don't have the photos in another way, I don't think those are coming in.
So, Ms. McLaughlin, you're not friends with Caitlin Albert, correct?
I'm sorry.
You're not friends with Caitlin Albert, is that correct?
I would say she's an acquaintance, not a close friend.
Now, you were shown some photographs of you in a fairly large group with Caitlin Albert, correct?
Yes.
Oh, Chad, there's no need to apologize. Chronicles of Shady. There's no need to apologize for the chat. The chat wants to know. I'm just letting y'all know why I'm not going to Twitter to try to pull stuff up, why I'm trying to find where they are, and why I don't know. It's okay. It's okay that you guys chat, but I'm really trying to keep it to what the jury knows, because we have to know what these attorneys are showing the jury. And it's frustrating to not know. It's like, who's Caitlin? Well, the last name's Albert, connected to this family somehow, but nobody's really tied it together. So no need to apologize. I just wanted the chat to know where I'm coming at with this.
You don't know when those were, correct?
I don't know exactly.
You don't know where you were when those were taken, correct?
No, not
Yeah,
exactly.
there's no
They
foundation.
seem old.
Not exactly isn't no, though.
Just to back up, you knew her in high school, but you weren't friends in high school, right?
I would categorize our
As acquaintances. We ran in the same group.
relationship as always being just acquaintances. I knew her. We had some mutual friends, but we were never close friends. We don't have a one-on-one relationship.
And
Same
as
group.
far as high school versus post-high school, would you see her more so during high school, the high school years, or after you graduated?
It's a good question.
Well, probably more.
Also, look at Lally asking really simple, direct questions today. Who the fuck is this? Where has this prosecutor been all week? Look at how simple the questions are. Now, what is happening?
In high school, just because you're there every day, but then afterwards,
Parallel universe
only
today.
here and there. Like I said, like mutual friends. So maybe events for mutual friends, I might run into her.
And to be clear, and I think you made reference to it, but that last photograph that's marked as K, that seems to be a cropped or sort of zoomed in of a larger photo. Is that right?
Yeah.
That's what she said.
Now, as far as each of those photos you were shown, you're present in a photo with Caitlin Albert in a much larger group, correct?
Yes.
Have you ever hung out or socialized with Caitlin Albert outside of the setting of a large group?
No.
Look how clear.
You've never been to her house before that date of January 29th that you know of, correct?
Correct.
She's never been to your house that you know of, correct?
Correct.
Who's the dude asking questions? Because that's not yesterday, Lolly.
Now, as far as that first one, that's as far as social media is concerned, as far as a friends list, and without sort of doing, and I'm sort of putting that in air quotes, how many friends would you say you have on social media in total?
I don't know. Maybe.
Which social media?
Maybe over 500. I don't know.
And of those 500 people, how many of those 500 people would you consider actual friends?
Much less than that. Less than 10.
7.
All right, why don't we wrap this up, Mr. Lally?
Ma'am.
When it comes to that day.
Oh, I was going to say, ma'am, you let the defense have all the reign they needed. I think she's already over it and ready to rule, and that's why she's telling the prosecutor she doesn't have any more questions. I don't know if that's fair.
That you responded, you're working with the fire department, you responded to a call on January 29th to a home, or as you say,
I don't think this is coming in.
Somewhere on the side of the road. Did you have any idea whose house that was adjacent to where the treatment was concerned with regard to your patient, Ms. Rose?
No.
I know.
Okay. All right. So there was an objection that this was in violation of Rule 14 to admit these exhibits, Mr. Lally. That's what you said, correct?
Yes, sir.
Okay.
I want to hear argument.
So I agree. So the exhibits don't come in, but based on this voir dire and the answers, I'm going to give you some leeway on exactly what you did. Okay. The relationship, the socialization and the extent of it, friends on social media, those areas. You didn't quite get everything that you mentioned at sidebar you thought you'd get. So that's not coming in.
So
if you
stay within the parameters.
So why don't you come over here then, just because.
She gestures broadly to the internet. All right. So here's what the judge has ruled. And I'm not sure I'm disagreeing with her at this point. I am spittling. Today has been the fieriest day of court so far. I'm not sure I disagree because there's no foundation for the photos. So the defense has not shown you can't just bring something in that a witness doesn't know and say, okay, that's the photo. But the judge is allowing in the line of questioning about how much they've socialized, which is appropriate. So he's going to be able to impeach this witness based on the information gathered from the photos, but not bringing in the actual photos because there's not any foundation for them. That doesn't mean they won't come in through another witness. If these were on her social media, he would have said, this is on your Facebook page, but he didn't. So these are not coming in. The photos are not coming in because there's no foundation for them and it violates the rules of evidence. But the testimony around how much they know and how much they've socialized does come in. So she said, I'm giving you some leeway on the impeachment of the relationship, but again, no foundation for the photos. So, somebody asked in the chat, did the photos not have more information besides the photos? No, they didn't. They didn't seem to. They seemed to be printed out off of somebody's social. They didn't seem to be subpoenaed. They didn't seem to be metadated. They didn't seem to be from this witness's socials. If they were from this witness's socials, it would be different. It doesn't mean that another witness won't come in and they won't come in down the road. They might come in down the road. So, what difference does it make? I imagine it makes a difference to the defense because the visual image of them like drinking a beer together matters, but the questions are still there. So I think the judge giving him more leeway to ask those questions makes sense. I'll pull Mass Rule 14 and see which rule of evidence it correlates to while they're asking their questions because I don't have the Massachusetts rule book in front of me. And it's not correlating directly to a standing rule of evidence.
If you all think they're right outside the door, you're mistaken.
Please be seated.
The photos don't have foundation. So I can't compare. They just don't have foundation. How do you know they're authentic? How do you know where they came from? How do you know what date? There's just no foundation. But he gets to impeach her on the questions. Thank you, Miguelina.
Jimmy, do you have any envelopes over there?
I do.
User error. So he's going to have broad latitude in questioning, but not using the exhibits. I'll pull the Massachusetts rule of court.
You know what? No, this is good. We're good. Just through the chat for Steve.
It's Rule 14 is rules of evidence, foundational evidence, how evidence is turned over, and discovery. So it's a foundation. It's a foundational exception. And I don't disagree with the foundational exception. They haven't proven the foundation. It doesn't mean they won't later. I mean, this is an 8-week trial, but you can't just bring a photo in off the street. And if somebody's like, I don't know where that's from, show it. If she said that she knew where it was from, then it would be different. But she didn't. So they're going to have to use another witness.
Did you say you had a water? Is there a water waiting for you out there that you need? Or?
I'm okay.
Okay, thank you.
Your Honor, would you like a water? You've just been roasted. The witness, I'm fine. She's still, all the questions are going to come in. And then the jury will get to decide if she's distancing herself from her relationship with Caitlin Albert or not. The jury gets to decide that. And he's going to have to question her so the jury can decide that. Is the jury not seated? Are we not starting? Why are we not starting? Danielle asked, why does her knowing Caitlin matter though? They haven't tied it together yet. Here's my guess. The house call was responded to was the Albert's house. I imagine Caitlin Albert is one of the Albert kids because they said, do you know any of her siblings? And if Caitlin Albert is one of the Albert kids, then don't you know that you're showing up at like your friend's parents' house, and don't you say something? Don't you call her and be like, why is there a dead dude in your dad's yard? Like, what? So that's what they're trying to get at. Did the story change because of the Alberts' influence? The defense theory of the case is this is a very influential family. So wouldn't you have called somebody? Wouldn't you have mentioned it to somebody? Look, I have friends in law enforcement that have called me when they've responded to calls in my parents' neighborhood. I live in Tennessee. I've gotten calls of like, hey, we responded up the street. Is so-and-so's dad okay? I understand why he's asking those questions. I don't know if I understand her answers. But that's for the jury to decide, not me. All right, the jury's now coming in. So, like, I get it. So, Linda D said, who called 911? This is not in evidence yet. So this is not in evidence yet. So we don't know. Mary said, thank you for the explanations. Helps me understand. You're welcome. It's hard to parse what's known and what's not known because there's so much known about this case. But what's in court is what we're going to try to ascertain. The Lauren said, so Caitlin's father is also a police officer. Yes. The home where the victim was found is the home of a police officer. And that is the defense's.
From time to time, there are things that I need to discuss with the lawyers, as you saw. We try and do it as quickly as we can. It's in an effort to make sure that what you see and hear in this case is appropriate for you to see and hear. So sometimes we spend a little time now that will save us a lot of time later. So we do appreciate your patience.
There are times, I know a lot of you guys don't like the judge, and particularly those of you that have been following this case, my jury is still out. But I very much like this practice of the judge of bringing the jury in and explaining to them why they've been kept waiting, telling them what's going on. She has been very conscientious of keeping the jury in the loop and explaining to them what's happening. And I think that that is better than a lot of judges I've seen. And she does it more frequently than other judges I've seen, which for everything else is very helpful. The sighing into the microphone annoys the piss out of me, but I don't think the jury can hear it. But she does seem very conscientious of their time and very mindful, explaining to them. So it's not just like, go stand in the hallway. And then they come back in and they're like, why are we standing in the hallway? She does explain to them in a way that I like.
Yes.
Thank you. Ms. McLaughlin, thank you for your patience.
I mean, she should mute her mic when she sighs.
Last left off, I was asking you about your relationship with Caitlin Albert. You recall that?
Yes.
I want to ask you a few more questions about that.
Let's see what comes in front of the jury.
You and Caitlin Albert have known each other for how long?
Since high school.
Which is, give me a span of time.
So
10 years.
Probably
I forgot
about
to
10
feed my
years.
Snorlax.
You have traveled with Caitlin Albert and friends. When I say traveled, I don't mean to exotic locations. I mean day trips, etc.
Yes.
You have a group of mutual friends together, correct?
We have mutual friends, correct.
Those mutual friends have gone on day trips with you and Caitlin Albert involved?
Correct.
On more than one occasion, as a matter of fact?
Correct.
On many occasions, matter of fact?
I don't know.
More than 5?
I don't know.
More than 10?
I don't know.
You've seen photographs of you with Caitlin Albert on some of these day trips, correct?
Yes.
You've seen at least 3 of those photographs.
Yes.
You're friends with Caitlin Albert on social media.
He is very carefully letting the jury know that these things exist, even though they're not going to see them at this point and maybe not ever. And not all lawyers would thread the needle this well without getting in trouble with the judge. He has brought it up in a way to clarify how she remembers. It is incredibly skilled questioning. Not a lot of lawyers would do this because he is using it to explain how she remembers these things, even though the photos don't have foundation and aren't coming in. But the jury now knows that there's photos. And just that gets left hanging. It's a very skilled level of questioning.
Other
Some
than
of
the
you
three
might like it.
photographs that you've seen,
Some of you might
just
not.
talked about,
But
there
it's
have been
very
other,
skilled.
Events that you've been at with Caitlin Albert that weren't necessarily photographed, or we don't have those photographs, correct?
Probably.
You know that Caitlin Albert is the same Caitlin Albert that's the daughter of Brian and Nicole Albert.
And whoop, there it is.
As you sit here.
Yes, as I sit here today, yes.
And you know that Caitlin Albert also has siblings, Brian Albert Jr., correct?
As I sit here today, yes, I know that.
And you also know, as you sit here today, that 34 Fairview
Streamyard makes it so easy. Look at that.
January 29th,
Alan, stop moving around.
The Albert home.
Sir? This is a small courtroom. This is not Los Angeles, my friend. Our courtrooms were bigger. Can you get back to the podium, please? So I can stay put on Alan.
Correct.
I know that as of today.
She's parsing. How do you guys feel about the parsing? Because his questions are kind of pointed.
You indicated.
But she is parsing the hell out of, yes, I know that today.
When you showed up at 34 Fairview
I don't
that
know how the
morning,
jury's going to feel about that.
did you recognize that address or recognize the home as being that of Caitlin Albert's?
No.
You have since learned that that was Caitlin Albert's home.
As I know that now.
And you gave your original statement to Trooper Proctor the next day.
Yes.
Did you know
that? That day to this day, or let's take yesterday.
Did you know then?
From that day to yesterday, you learned
the defendant
that 34 Fairview was the Canton Albert family home, correct?
You're asking if I know from...
Between those 2 dates.
Yes.
Between the time you spoke with Trooper Proctor in this report till yesterday when you testified, you now know that that's the Albert home.
Yes.
And you also indicated that between that...
At this point, chat, do you need the pictures? Or has he made the point?
Report that you gave to Trooper Proctor, that statement that you gave to Trooper Proctor, and yesterday's testimony, your statement has evolved. You've already admitted that, correct?
I don't think I agreed with you on that.
She's like
changed.
She's like you did agree with him.
I've always testified to my. I feel as though my testimony has been consistent.
I appreciate how you might feel. I'm just interested in the actual facts. You didn't tell Trooper Proctor anything about this officer questioning my client.
That water?
Objection. So I'm going to see counsel at sidebar because I think this morphed in.
He's now moved on from the relationship and the judge is like, what is even happening? But again, if there's no foundation for the pictures and they come in, it becomes a problem. Does he even need them at this point? Because she is distancing her, like backpedaling away from how she knows Caitlin. Other witnesses, especially the law enforcement witnesses, we saw other witnesses say, so this is wrong on the reports. Yep. So this is wrong here. Yes. So that was an error. Yes. And it came across as very truthful. But when everything is parsed, it does not read well for the witness, in my opinion, because everything is parsed. You guys have to let me know. Do you think the defense is going too hard on her and making it look like it's more than it is? Or is she being too evasive?
The Trooper Proctor is not the same as the statement that you gave to these jurors yesterday. Right?
Yes.
Bingo, Stephanie.
Yes.
couple of other questions. When you did make this statement to Trooper Proctor, your visit to Canton PD was coordinated by another officer to put you and Trooper Proctor together for the interview, correct?
I don't recall that.
Do you recall being contacted by a completely different officer to say, hey, Trooper Proctor wants to talk to you, come on into Canton PD, let's have an interview?
I don't remember exactly how the interview was set up.
So that was my next question. You may have just told me this. Do you have any recollection who set that interview up?
I don't.
His name Kevin Albert sound familiar?
No.
You know Kevin Albert?
No.
Who's Kevin Albert?
Police officer at Canton PD.
No.
Now we know.
To be the brother of Brian Albert.
No.
The objection sustained.
Wait, I want the information though. Back up. I know it's sustained, Your Honor. I know it's not information, but you can't put that shit back in the horse either. Oh dear. I now want we're backing up because it's more important now that we know. It's like, wait a second, the brother of the homeowner is the first one that contacted you.
You agree, Mr. McLaughlin, that the statement that you gave to Trooper Proctor is not the same as the statement that you gave to these jurors yesterday? Right?
Yes.
Yeah, just tell me that.
Yes.
So for those of you asking if you can treat her as a hostile witness, no, she's not. I'll explain that. I'm holding on to those questions. I'll explain it. They're already on cross. So no, that's not quite what that, her being annoyed does not mean she's a hostile witness. I'll explain the legal meaning. It goes beyond being annoyed. She hasn't told him to fuck off though. I mean, so she's not as hostile as some witnesses I've seen. Her face maybe does.
A couple of other questions. When you did make this statement to Trooper Proctor, your visit to Canton PD was coordinated by another officer to put you and Trooper Proctor together for the interview, correct?
I don't recall that.
Do you recall being contacted by a completely different officer to say, hey, Trooper Proctor wants to talk to you, come on into Canton PD, let's have an interview?
I don't remember exactly how the interview was set up.
So that was my next question. You may have just told me this. Do you have any recollection who set that interview up?
I don't.
His name Kevin Albert sound familiar?
Fucking hell.
You know Kevin Albert?
No.
You know him to be a police officer at Canton PD?
No.
You know him to be the brother of Brian Albert?
No.
The objection sustained.
I hope the defense backs that up, that the original officer who contacted her about an interview is the brother of the home where they found. I hope that they back that up later in other evidence. But you again, you can't unring that bell.
That's all I have, Your Honor.
Okay.
Yeah, I bet it is.
Redirect.
Yes.
Because they're so smart. Look, you guys, he left the question that is the bomb of all of this for the end. It's an inappropriate question, but the question, and they pick and choose when they do it. It's right there on that line. Because, well, why would it be objectionable? She doesn't know, but she could know. I don't know if that's appropriate to sustain. Because they don't say the grounds, it's hard to think what the lawyer's thinking. Here's where I'm at. He has reason to believe that she might know that because she knows Caitlin Albert. So he has a foundation for why she might know that the law enforcement officer that contacted her is the brother. I don't know why it would, I don't know why it would be an issue. For those of you in the chat saying I'm fangirling, look, it's good lawyering. I'm always a fan of good lawyering. It is good lawyering. And it's very, very good lawyering. It's not speculative because he's asking if she knows. Do you know? I'll have to think about that one later today because that was great questioning. And now he's like, bye. We're going to leave that hanging in the air. Bye. Bye.
So Firefighter McLaughlin, you went to high school with Caitlin Albert, correct?
Yes.
And could you describe the nature of your relationship, if any, with Caitlin?
I would.
Who is this fucking prosecutor? Where has he been for the last week? Look at how clear those questions are. Is the defense making Lolly step up his game? Because those are way better questions.
Describe it as we're not close friends.
Look at this redirect.
I would say we're more acquaintances. We have mutual friends. I don't have a one-on-one relationship with her.
Look at that redirect. He let her explain.
We're asking questions about social media, correct?
Yes.
And if you could, or if you could guesstimate about how many friends, and I'm sort of throwing air quotes in there, how many friends on social media would you have?
I don't know, probably 500.
And of those probably 500 friends on social media, how many of those are actual friends that you talk to, interact with beyond social media?
Much less than that.
Now, prior to, well, let me ask you this. As far as, would you say that you saw Caitlin Albert more so when you were in high school?
Look at how direct these questions are.
Have graduated from high school?
I would say probably more in high school because we were there every day. So.
And about what year or so was it that you graduated?
2014.
And as far as any sort of photographs that were referenced to you,
Lally, I know it's off topic, but can you also ask her skincare routine? The chat's really curious. She just has delightful skin. Look at this questioning. Whole different prosecutor showed up this morning.
have you seen those photographs?
Here?
Yes.
Here today, I saw them.
Do you have any idea where or when those photographs were taken?
I don't remember.
The jury's going to be like, what photos? Did we get to see the fucking photos?
It's not just you and Caitlin Albert in a photograph. Is that correct?
This is actually one of his best
A
redirects.
larger group of people. Is that correct?
Correct.
When you were asked about sort of these day trips, they were sort of trips specifically on a day to a beach, it looks like, correct?
Correct.
And to a beach with a larger group of people. Is that correct?
Correct.
And with reference to Caitlin Albert specifically, have you ever socialized with her in any setting beyond a setting that contained a large group of people?
No.
Now, with respect to, you went to, you say high school, you graduated from Canton High School, correct?
Correct.
And you grew up in Canton, is that correct?
Yes.
And did you know Caitlin Albert before you attended Canton High School?
No, that's probably when we first really interacted with high school.
How many elementary schools are there, though?
Essentially, you live within the town I'm sorry, you work within the town that you grew up in, correct?
Correct.
And is
always fucking awkward, by the way. My question for Lally is, did Caitlin graduate the same year? Nobody asked. Like, was she in your graduating class? Were you just mutuals? There's not any connection back, but this is the first time on redirect he's actually like followed up on the things that were damaging and let the witness explain. Whether that helps or not, I don't know. But they're letting the witness explain.
Abnormal from a civil service perspective?
No, from a civil service perspective, you're given more points for residency. So it's actually, I would say, preferred, or you're placed higher on the list if you have residency in that town.
So it's actually preferred and more common than uncommon as far as growing up in a town and then working in that same town in a civil service position like a fire.
Lovely, that's good questioning.
Yes. Now,
who are you?
During the course of
it's a real good question.
You've been on the Canton Fire Department, have you received calls to residencies or other places or even patients that you either knew or were familiar with?
Yes.
Would that be a reason for you to not go on a call?
No.
And you have an obligation, wouldn't you say, to respond
Look
to a
at
call
that,
when
an
the
effective
call is made and you're
redirect.
on duty in that station house, correct?
Yes.
You go when you get called.
Objection sustained. Ask the question differently.
As far as when
I didn't hear the
you're
problem
on
I was
duty
talking.
as a firefighter at a particular station house and you get a call, what, if any, choice do you have to respond to any particular call?
I don't have a choice. I just have to respond to the call.
And then prior to that date of January 29th,
It's a good redirect.
have you ever been over through socialization or otherwise Caitlin Albert's house?
Not that I ever remember.
Has she ever been over your house?
No.
And again, had you ever socialized with her outside of a large group of people?
No.
When you responded on that morning, just after 6 a.m., the house of 34 Fairview Road, did you know who lived there?
No.
During the time since January 29th of 2022, have you ever spoken to Caitlin Albert about what happened that morning in front of 34 Fairview Road?
No.
Now, you were asked some questions on cross-examination about knowing sort of Caitlin Albert's parents' names or siblings' names or things of that, correct?
Right.
And prior to January 29th, you didn't know any of those names, is that correct?
No.
You learned of them subsequently, is that correct?
Yes.
May we approach just briefly?
Okay.
So as I am going through Rule 14 and I was reading it as I saw a super chat come in, and our super chats are not auto-saving, so if I don't get to everybody's, that's helpful. Kelly O'Leary, thank you for the comment. Kelly said it's mandatory reciprocal discovery in Massachusetts, and I was going through all of Rule 14 more thoroughly as Lolly was actually redirecting fairly well this witness. That there is a continuing duty of both the defense and the prosecution to continue to turn over any evidence that they are required, which is different than rules elsewhere where the defense is not obligated to turn over impeachment materials. So that, I think the foundation is the biggest issue, but the reciprocal discovery that it's never been turned over is also going to be an issue if they are obligated to turn over things that they've had, which explains why the judge asked to this point, how long ago did you pull these things up? And he's like, year and a half ago. And the judge was like, sir, and the defense has never seen them? You got to turn it over. What you got to do is turn it over. So I appreciate that super chat as I was reading through the continuing duty. Thank you of Rule 14 in Massachusetts. So that's helpful to know. Question, why do the defense have to turn over something that is public information? Because if they intend to use it, they have to turn it over. And if it's not from this witness's socials, you don't know who they're pulling it up from. So interesting unfolding here for me is that Lolly actually has been redirecting well. The questions he's redirecting is, okay, so you've gone on calls with people that you know, yes. And in civil service, you actually get additional points to get hired if you live in the area where you're going to work. There is an emphasis on hiring people that are local, which makes it look less sus, like, oh, doesn't everybody know everybody? It's actually explaining to the jury, well, yeah, this witness might know a lot of people because she grew up here. And actually, we try to hire people. The civil service there, we try to hire people that grew up here. That's what we want to do. But the jury, the local jury is going to know this because this is their experience every single freaking day. Very, very, oh, my husband's making Brussels sprouts. I can smell it. Dr. Baker.
The Albert family, subsequent to your response to this call on January 29th. Is that correct?
Yes.
Ugh.
And you learn of those through sort of various news or media reports in relation to this case, not something that you had any conversations with anybody about, correct?
Correct.
I have nothing further.
All right.
That was a good redirect, Lolly.
Okay. Okay.
You indicated, Ms. McLaughlin, Mr. Lally just asked you about these 500 friends on social media. A couple of quick questions about that. Of those 500 friends on social media, how many of those have you taken day trips with?
I don't know.
How many of those have you gone to the beach with?
I don't know.
How many of those have you posed for photographs with?
I don't know.
How many of those have you posed for photographs in swimwear with?
I don't know.
How many of those have you been photographed with your arm around while that other friend is drinking a beer?
Sustained. Sustained.
That's too
Mr.
far,
McLaughlin,
sir.
All of those things that I just mentioned, you have done with Miss Caitlin Albert.
Nope.
Objection, Your Honor.
Too far.
Sustained.
Too far. You can't describe the photos.
Okay. All right, Firefighter McLaughlin, you are all set.
The overreaching might turn off the jury. We'll talk about it in a minute.
All right, jurors, we are
Going on
getting
their
ready
view.
to go for our view. So we're about to visit a place which you'll be hearing about some more. You've heard about, you've seen photographs of. And in court terminology, we call this a view. The purpose of the view is to help you better to understand the evidence, which you'll hear during the trial, and to help you appreciate the location and its surroundings. The view that you will take is a part of this case. The observations that you make while on the view may be used and considered in your deliberations in reaching a verdict. The place that we're going to go, you've seen photos of, you've heard it, it's 34 Fairview Road. The lawyers and I will accompany you on the bus. The attorneys may point out to you the arrangement of the scene and items that they want you to pay
Interesting.
special note of, but otherwise they cannot discuss anything in this case
That's
in
interesting.
regard to this case, and they can't talk to you. All right, they'll be able to do an opening here, and they'll be able to point these things out. While you're on the
I
view,
appreciate the
it's very
explanation.
important that you can't take notes, and you certainly can't use your phones and take photographs. All right, it's really just for you.
Maybe they should have had a crime scene fucking photographer at the crime scene so everybody could see where it is. Maybe. That's not the judge's fault, but I'm salty about it.
To see. You cannot conduct any independent investigation while we're there or at any time during the trial, as you've been told. You're not to return to the scene or ask anyone else to do it for you until the case is over.
expecting
So
the judge
this
to
is
have a
your
Stanley.
opportunity to take a look when we go.
It doesn't look like a
What you
Stanley
are
up
to
there.
do in
I
the
like the
view
color,
may be
though.
best summarized in two very familiar words, which is stop and look. Okay. Your responsibility is to see the place, to observe it carefully, and to remember what you see. So during your trip to and from the place that we're going to view, you're not to discuss this case or anything about it among yourselves or with anyone, and you are not to permit anyone to talk with you about the case. You'll be under the supervision of our great court officers at all times, and you'll remain together until you return to court, unless the court officers direct you otherwise. And just so that you know, because some of this came up during our jury selection process, spectators, if there are any, and all members of the press have been ordered to stay 100 yards away from you.
Yeah,
all right,
don't
so you
fuck with
can
this
go
jury.
and you can look and take your time looking without worrying about any interference from anyone. All right.
Yeah, that would
so
be a
with
huge
that,
issue.
Mr. Clerk, could you swear in, please, the court officer?
Court officers, raise your right hands, please. Do you solemnly swear you will take this jury upon the premises in question and there suffer them to view the same in any property, place, or thing bearing upon the issues on the trial, as they shall seem necessary? That you will not permit the parties to enter in a debate in front of the jury or a person to speak to them unless it be Adam Lally for the Commonwealth and Alan Jackson for the defendant. They to point out such places or things as they deem expedient for the determination of the issue, and that you will keep the jury together until they shall return into court, except the court shall otherwise order, so help you God. Thank you.
All right. So Mr. Lally, do you want to do a short view opening?
Oh,
thank you.
Okay.
I'm so glad we get to hear it.
So, ladies and gentlemen, as Her Honor just described, we're about to go to a place. When we arrive there, and at any point in time when we're there, this is not a point where we can have any sort of conversation or back and forth. So all I'm going to be asking you to do is just take note of certain locations and certain items as you see them. And again, as with anything in this case, this is as you find them, as you observe them, okay? So first I'm going to ask you to sort of, when we arrive in a general area, as far as—
I've not seen this done this way.
Sort of street names when you're coming into and when you're exiting from this particular area. When we arrive at a specific location, I'm going to ask you to take note of certain things about the roadway, okay? Certainly any abutments to the roadway, any residents.
Did somebody swap out prosecutors? Because A, easier to follow, B, very clear. There is no mincing words or what if any. It's a whole different situation. We'll talk about the defendant. The defendant's not allowed to go on the view. We'll talk about that after this.
That you observe the distances between the roadway and any landmarks or any items that you observe on that property, specifically a driveway, specifically a front door, any other sort of items of interest within the front lawn area of that home. I'm also going to ask you to take note of the roadway itself and sort of the width of that roadway, whether or not you find any sort of lanes separating within that roadway, and then the individual width of some of those lanes as well. Lastly, there is also going to be a vehicle there as well. And I'm going to ask you to take note of certain things with respect to that vehicle, okay? With respect to the size of the vehicle, with respect to the height of the vehicle, with respect to...
Are they bringing the Lexus out of impound to go to the view? Oh, that's fantastic. I'm very interested to hear more about that. But if it's the defendant's car, shouldn't you just say that?
Anything that you observe specifically from the front, the side, the back, all of the exterior of that vehicle, and then also some of the interior of that vehicle. And specifically, I'm going to ask you to take note of sort of the center console in the front driver's compartment of that vehicle, and anything that you observe in that location as well. And that is all I'm asking you to do on this case, and I thank you again for your time and attention.
All right, Mr. Jackson.
Thank you, ladies and gentlemen. It's the first time we've been able to speak to you directly, so I want to take the opportunity to introduce myself and thank you for your service.
They know who the fuck you are at this point, Alan.
I'm going to echo a lot of what Mr. Lally just said. There's nothing magical about this other than it gives you perspective. It's an opportunity to introduce you in three-dimensional form to stuff that you've been seeing in two-dimensional form. Photographs, some of the testimony, diagrams that you might see.
So I'm sorry, we're really pointed on what you can say.
What we're going to ask you to do is take special note of the relationships of physical items out at the scene. Much as Mr. Lally just indicated, there are going to be physical things out at the scene. You've heard about a flagpole, a fire hydrant, a house. We're going to ask you to take special note of where those are in relation to other things physically at the scene. That will hopefully, with the court's instruction, give you some assistance in putting together the testimony that you think is relevant and the documents that you think are relevant. And again, to echo what Mr. Lally said, we're going to ask you to look at the roadway, the vehicle, the house, the physical items at the home, and the relationship between and among all of those things to each other. Hopefully, that will give you a very good understanding of what we're dealing with, especially with the exhibits. Thank you.
Okay.
All right. So, folks, we'll be all set. We'll see you at the bus in a little bit.
Just make sure your notebooks are closed.
What time are we back in court?
Muted.
Anyone?
Goodbye.
No, goodbye. When are we back? Your Honor? When? This is why you need the Lawnerd app. Wait, why does this go back to court? Wait, something else happens.
One final record.
Hold
of
on.
the court's ruling.
Hold on.
I respect the court's ruling.
But wait, there's more. I was just zooming. But wait, there's more. No goodbye. I'm going to answer questions when we get to questions, but they're putting something else on the record and I want to know what it is. So
Sorry for the false start. Your Honor, I'm so sorry for the false start. I wanted to make one final record on the court's ruling.
I don't know how the judge will feel about him not doing this at sidebar and doing it publicly out in the open, but I'm real glad he is. Because I want to know what the fuck is going on.
I respect the court's ruling on the
Go ahead. You can make your record.
Maybe it would be better if I did it over here. I wanted to interpose an objection to...
So I think it would be better if you did it over here.
No!
It's just illegal.
I don't know what you're doing. Come over here and tell me what you're going to do, and then I'll take you back and do it.
No! Stop it! Just let them argue. The jury's out of the room. What are you doing? Stop it! She is so afraid of these lawyers, it seems to me. This is just my gut opinion. This is why I did not watch motions before going into this trial. She's like, I don't know what you're about to do. Like, why are you so, look, sanction his ass if he does something that you're upset with. But Your Honor, there's no jury in the room. The jury's not supposed to be watching any of this. Just let them talk. The internet is curious.
Yes.
Like, let him make his record.
To the
Fuck.
4 exhibits that the court deemed were not admissible because of a violation of Rule 14, I wanted to elaborate just very briefly.
Go ahead.
Our objection.
Okay, so he's not saying it's a foundational issue.
That under Rule 14,
he is saying it's a reciprocal discovery issue, and now we're going to get to hear the argument on it, which is really, really helpful.
we were not obligated to have to present these exhibits to the Commonwealth in discovery. Rule 14 does not require such disclosure when the exhibits are used for impeachment only, and that's exactly what those 4 exhibits were going to be used for, and what we intended to use them for. Had this witness said, "I know Caitlin Albert. We've been friends for 10 years. We went to high school together.
It never would have come
on
up.
Day trips together. We've been to the beach together, and we've socialized together," I wouldn't have to show any photographs. But that's not what she said. What she said was, "I went to high school with a person named Caitlin Albert," which is a bastardization of the truth. That's not the truth. And those 4 photographs are what got her in the voir dire process, what got her to admit
it impeached her.
That she in fact does know Caitlin Albert, and those are on a very, very different level than she first suggested. As the SJC is explained in the case of Commonwealth versus Aguiar, Aguiar, at 400 Mass 508.
Oh, he's got the case law already.
Site at 513. It's a 1987 case.
I still don't know that there's
says
foundation.
The following, and then I'll finish my record. Quote, "A defendant has a constitutional right to bring to a jury's attention any circumstance which may materially affect the testimony of an adverse witness, which might lead the jury to find that the witness is under an influence to prevaricate. It matters not that the evidence would reveal
this case is from 18-1
fact, such as the witness's commission of a crime. A judge may not restrict cross-examination of a material witness by foreclosing inquiry into a subject that could show bias or prejudice on the part of the witness," end quote. That's exactly what we believe we were entitled to do.
To show bias.
McLaughlin as a witness for the Commonwealth. She has bias.
Oh,
Or
1987.
at least the jurors can consider a bias. She has prejudice. The jurors could consider a prejudice because of a pre-existing relationship with Caitlin Albert, about which she was not truthful. So I wanted to make that record and ask the court to reconsider whether or not those 4 exhibits could be introduced. I don't need to make any big deal about it. I don't want to call her back to the stand.
Just needs to make a record.
The jurors, now having had the description of those photographs, should be able to see them in evidence. And I would submit.
Lay the
All right,
foundation
so
for
that
them.
request is denied. The record's clear. So Ms. Reed is not going on this view. She just needs to make sure she's back here by the time we return. So
Which
Mr.
is when?
Yannetti, you're nodding.
Yes,
You will
understood.
contact her and make sure
Understood.
she's back here.
Understood.
All rise for the court, please.
Well, I'm glad he got to make his record. I still think there's a foundational issue as to the photos, but whatever. My issue with the foundation is neither here nor there. He is saying that Rule 14 on reciprocal discovery. Let's see if there's anything else. Spicy. Nope, that's the end of the feed. Okay, or the end of the feed for now. Let me kill this so I don't keep looking at spinning wheel of death and summarize. Well, I'll summarize his argument when I summarize the morning. It's 10 a.m. Let me just make a note again. I will let you know when we're going to be back in court. It might be a little delayed from when the court goes back on because I am waiting to see when they come back. I have reached out to the court and asked. Nobody knows. So nobody knows when court is resuming. We're just going to have to wait and see. But I will be live this afternoon. I got to go finish doing my hair for the band banquet tonight, but I will be live this afternoon. The Law Nerd app is where I am going to alert you when we are going live. And it's going to probably be 1 or 2 o'clock local time in Massachusetts. So 1 or 2 Eastern is what I'm thinking is when we will be back. It might be later than that, but when we are back, we will be back. The difficult thing with this case is even some of the media stations don't seem to know, and they go live the second the feed's available to them. So we don't really know what's happening. Free app, iOS, Android. We will ping you immediately. So it is 11:15 a.m. local time. I can't imagine they'll be back before 2 local time, if not later. So it's going to be later this afternoon. And then they end right at 4. If the jury view takes a while, then and lunch takes a while, they might not resume, but I think that they will. They told the defendant to be back. So with all of that, let's do a quick summary and answer some questions. But I had some issues on my end with some of the super chats not getting captured. So I need to refresh my stream on my end. So I am going to put up our StreamYard music because I love it the most. And then I'm going to put up, there we go. We're going to put up the Be Right Back because I just need to refresh my screen. This morning's been like, we're in like a real trial now. I'm all flustered in a good way. It's real exciting. So I'm going to put up my overlay. I will be right back. Literally, BRB. Hold on. Oh, I can't do both at once. It's mad at me. Ooh, Miguelina, we can add like a background. Okay, Emily, stop trying to redo the stream and just refresh yourself. I'll be right back. Did you miss me? All right. Thank you, Chad. That refresh worked. Let's refresh our vibes. That refresh worked, and so now I can see all of your super chats. Very excited about it. So thank you, StreamYard, for handling that for us this morning. I love working with StreamYard. They make it easy to continually move my face around when Alan Jackson wanders around the courtroom that's the size of a postage stamp. But I love our vibey music and that they just fixed it while we were on stream. So let's summarize this. Guys, do you feel like we were in a real trial today? I'm just like, look at us, kids. We have a real trial. We have prosecutors asking like actual concise direct questions. We've got defense attorneys being feisty over impeachment. We've got actual trial happening. It only took till Friday. Cheers, everybody. We did it. We're here. We're here and we get to watch trial happen. Let's do a quick summary of the morning. Oh, where's my swoop? Today, I've lost everything. Runkle, good to see you. Duty Ron, good to see you in the chat. Let's swoop. Runkle said, what did I miss? Runkle, you missed the lawyers lawyering this morning. Court happened this morning. Like an actual trial happened this morning. I can't wait to see. There was impeachment. Oh, wait, I'm going to do a summary. Emily, you can't just talk to your friends. Okay. Law nerds, all of you, all 18,000 of you in here. We can't just, well, yeah, we're going to. Let's just do it. Well, we have a real trial on day 4 of the Commonwealth versus Karen Reed. Remember, the Commonwealth is accusing Karen Reed of striking her boyfriend, Officer John O'Keefe, with her vehicle and leaving him to die in the snow. The defense, as they said at the beginning of their opening statement, says Karen Reed was framed and that the home where the victim was found is a very prominent family in the area, the Albert family, and that factors into this case in a big way. And for the first time, it came up in court today. Remember, when we resumed day 4, we were on witness 9. Firefighter, wait, I'm going to double check so I don't get it wrong. Hold on. Firefighter Katie McLaughlin. As we got to the end of Katie McLaughlin's testimony, we got some clarification about the I hit him statement. That didn't come in through the prosecution. It became much more clear on cross-examination. A lot of things in this trial have so far been that way. And what became very clear is that when Karen Reed said, I hit him, the fire medic asked her the question. She turned to another woman who is yet to be identified. Internet, I know you know, but in this trial, it's not been identified yet. Turned to another woman and was saying that to the other woman she was talking to in response to the question. And then Katie McLaughlin went back into the ambulance and told individuals in the ambulance what had been said, which contradicts testimony of the previous paramedics who said that they heard Karen Reed say those things, not that Katie McLaughlin told them that that's what was said. What she also clarified is that one of the officers on scene was standing right there when it was said, and she didn't put in any reports because she's like, there is a police officer right here. What we know from prior testimony is that those officers didn't really do anything with that information to treat the scene like a crime scene. In fact, Karen Reed left the scene after all of this happened and no one stopped her from leaving. So we now have more clarity on how things were said and why, which leaves a lot of doubt as to whether Karen Reed was saying, I hit him, or looking at someone saying, I hit him. And there is a big difference for this jury between the two, I would imagine. Then we got into impeachment of that witness. The jury was excused and there was a substantial voir dire of the witness with some photos from the defense that had not previously been turned over to the prosecution. The court said that that violated Rule 14, which is the rules on discovery in Massachusetts. Thank you to those in the chat that pointed it out and to Google for pulling it up so quickly. But the defense argued after court wrapped for the morning that the reciprocal discovery obligations do not include impeachment discovery, which is consistent with most jurisdictions that we've covered and the jurisdiction where I practice, that if it is impeachment evidence from the defense, it does not need to be turned over. And that's what Alan Jackson made a record of at the end. What was it? Photos from social media of fire medic Katie McLaughlin with Caitlin Albert, the daughter of the homeowner where the victim was found. So now we have, how well do these two know each other? And the witness was distancing herself from how well they knew each other. She said they're acquaintances. They have a lot of mutual friends and groups. Yes, there are a number of pictures of them together. She said they looked older and they were from social media. The defense didn't have any foundation, it seems, for when those pictures were taken, whose social media those photos came from, and didn't ask any of those questions. So we don't really know if those pictures were posted by the witness's social, if they were posted on Caitlin Albert's social, if they were posted on somebody else's Facebook and everyone is tagged. We just don't know because there wasn't foundation for that. And the witness was not impeached on the date those photos were either posted or taken. We don't know. So what the jury heard was that the photos existed. There are photos of them together. There were times that they socialized and that they were acquaintances. And then the defense got into the questions at the very end of that cross-examination saying, was the officer that reached out to you to interview Officer Albert? And she said she didn't remember. And then asked if she knew if that Officer Albert was the brother of the homeowner. And there was a speedy objection that was sustained. But now we also know that one of the officers involved in the investigation, it seems, from this question, is the brother of the homeowner. So we are starting to get into the little bits of the interconnectedness of this small community. To the prosecutor's credit, on his redirect, he asked very concise and direct questions about civil service, how the fire department hires, and that priority is given to people who live locally. That when they're called out to a call at the home of someone they know, that they can't just say, no, I know them, because everybody knows everybody. And so the prosecution, I think for the first time on redirect, did a very good job of saying, right, but you know people who live here and you go to calls anyway. But it doesn't undo the fact that, again, this was not covered in direct examination, that at least in a mutual group, this particular firefighter, who's the one that heard the I hit him statement and related to everyone else, is friends with the daughter of the homeowner where the victim was found, which plays into the defense's theory of the case. But a different prosecutor showed up today so far. Now the jury is going on a view. The judge did something that I really liked in getting ready for this jury view and explained to the jury what the purpose of the view was, read them the jury instructions about how it would happen, and was very informative with them on this is what's going to happen. This is what to expect. This is how people are allowed to interact with you. This is the distance set up so other people don't interact with you. And then the lawyers got to make a jury view argument, which I have not seen in other jurisdictions, where in open court, they got to say to the jurors what they wanted them to focus on. And we heard from the prosecution that there will be a vehicle. They didn't say it was the defendant's vehicle, which they probably have in impound, but that there will be a vehicle on scene, and they want the jury to get a sense of the size of the vehicle, the interior of the vehicle, the dashboard of the vehicle, and get a sense of the distance of where the fire hydrant is on the property, where the flagpole is, and some of the other landmarks on that property that we've seen in the photos. Because, well, you know, it's May 3rd and it's not snowing in Massachusetts, according to the chat. April's sketchy, but in May, I think there's no snow. So the defense then started to get into more of an opening statement type conversation or colloquy with the jury. And the judge was like, there's limited things you can say. And he redirected back to, we want you to pay attention to the distances and put kind of three-dimensional context to this crime scene. It was a very, very interesting day in court. A totally different trial showed up today, and I'm interested to see what happens when they come back this afternoon. And with that, we're going to get to your questions. So, Law Nerds, what a day. That wasn't even a short summary, but I think I covered it. Wow. What? No, that wasn't my FAQ. Y'all, what a day in court. Natasha coming in from Northern Ireland. Good to see you. Or North Ireland. KMacD, thank you for the very generous super chat. Thanks for the case coverage. Thank you for the coffee fund, among other things. I've got the sack lunches and Capri Suns for our field trip. You're ready. They're on their field trip now. K. McD said, so close to 40 months. That's amazing. With the updated gavel after 36 months. I'm going to get to questions as best I can, and then we will get to some of the other comments. They said, no, it's Northern Ireland. Look, my brain is going at like 1,000 at the moment. So I apologize. Like 1,000. Bell said the judge's audible sighs are highly off-putting. I think so too. I hope that the jury can't hear them. It seems that the audio that's being fed out to the media is from a called in Zoom call. So the cameras aren't going through, or the microphones aren't going through the courtroom. So we're not hearing that. Will court come back today? It's supposed to be. Freedom Lover said, Emily, you know the photos should come in. Freedom Lover, I absolutely disagree with you. They haven't laid a foundation for them. So until there's a foundation, no, I don't think they should come in. You can't, as much as you might want to, you can't just grab a photo off the internet and bring it into court and say, admit the photo. There has to be foundation for it. And right now, there's not foundation for it. The rules of evidence are finite. I think the way that the judge allowed him to question the witness about it was appropriate. And he questioned about the photos. The jury knows they're the existence. I actually think it might be better for the defense to not show the photos, because the jury might think that those photos show them being closer friends than large group photos. So I disagree. There is no foundation. I don't know if it violates their rules of discovery, but we haven't seen foundation yet. It might come in with other witnesses though. This is a long trial, and this is not the end. We're not even in the defense case. The defense can call whoever's Facebook page they came from and bring them in. But no, I don't think at this point there's foundation for the photos. So, no, disagree. Let's see. What, if anything, do you remember from the prosecution? That it snowed. Today I remember much more. Figuring out, KC said she has a very selective memory, and the jury will see that and take it as they will. Because she definitely distanced how much she knew herself. And then the defense was like, but there's pictures of you guys hanging out together on multiple occasions. She's like, oh yeah. I mean, you all went, ma'am, what? And I know for those of you that know a lot about this case, that it's hard to parse what you know and what the jury sees. For those of you that know nothing about this case, did that surprise you? How she was like, oh, we're acquaintances, and then there's all these photos of them together. Were you just like, wait, what? So answer, if you came into this case cold, like the jury, and didn't know, did it seem that she was downplaying how well they knew each other? Just let me know how you read that situation, because that's helpful. For those of you that know a lot about the case, it's very hard to parse what you know from before and what the jury is seeing. And so that's why I think it's so helpful that so many law nerds have jumped into this case now, because you get a good read on not knowing what's going on outside the case and waiting for the lawyers to show it to you. And I am waiting for the lawyers to show it to me. And so far, every time there's cross-examination, I'm like, oh, that makes more sense. And when the defense is more clear than the prosecution, it's not good for the prosecution. Janice said, did he even make it into the house? That's my number one question. The defense says yes. The prosecution didn't make it clear that they say no. They haven't made that clear yet. So we don't know yet. This jury doesn't know yet. The defense theory is no. Megan said 11:15 p.m. Friday in Melbourne. I'm drinking Pepsi Max and crocheting. Love catching live court with you and chat. Love seeing you too. So many talented law nerds in the chat. When we get to the PO box this weekend, I'm gonna have to share some of the stuff that it's been a minute since I've opened stuff, but so many incredible crafters in our community. Kentucky Law Nerd said hello from Kentucky. My sister is giving birth to my second nephew this morning. Congratulations, Mazel Tov, cheers. EDB might love to know he is named after a whiskey spelt differently, but it's also my last name, Jameson. That's delightful. And Jameson is such a lovely name, and it's Kentucky. I love that they picked a whiskey, not a bourbon. I also really like Jameson, so it's all good. Katie Bug says, why does this prosecutor still have a job? Look, man, civil service is a real thing, but we saw a different Lally show up today, so I'm real interested to see how this case goes. Totally different prosecutor today. Very interesting. Ike? I'm going with like Kiki, but with an A. Ike? Kiki? I'm sorry. My brain has paused on the A and the I together. Economy. We'll go with that. With how bad Proctor was for the prosecution's case, they should have got in front of it in their opening statement. I don't know if they can. It's not lost on me that the prosecution and the defense, because of all the external investigations happening, asked for this case to be continued. But yeah, the Proctor stuff's real bad. It is definitely the dark cloud hanging over this case, because I imagine that the little things are going to continue to grow. And if there's this many little things early on, it's going to continue to grow. I can't see how they undo that. Burhana said, personally, I think the easiest narrative to follow is the one that doesn't require 24 people across half a dozen agencies to be involved in an impromptu conspiracy that not one has accidentally busted out in 2 years. I get it. And I think a lot of people have said this many people can't keep a secret. The thing is, for the defense, they don't have to really prove it. They just have to make the jury question it. And right now, there's a lot of questions in this case. Like a lot of questions in this case. We'll see if the prosecution can answer them. But when there's more questions than answers, that's just doubt. And you can't get past it. I still am not clear on why why the prosecution chose to elevate this beyond an accident. I don't, where's the intent here? And how are you going to show it? And maybe they will and they'll change my mind. But right now I got questions. That's where we're at. Matt Bond said, yay, back to court's only fan. The only fan. So Charlie Wilson said, I'm having top surgery on Wednesday. Congratulations. I'm so excited, but very anxious about falling behind in my law classes. Hopefully we'll only miss 2 weeks. I imagine that everyone will be very accommodating. I would imagine you're, Charlie, at the end of the year, right? Make sure your professors know so they can support you and you will get caught up. Look, I was telling Hogue this yesterday on stream. It's going to work out. You've got this. It will work out. So your professors are there to help you. So make sure you invite them into that process. You've got this, and recover well. Keep us posted. Ugly Planet said, do we take a shot every time the judge sighs today? I have places to be. I can't. My liver cannot. Katie Bug said, I think that's sorry, but the fam won't get justice without the prosecution, in my opinion. I am just hoping for clear answers in this case. That is what I am hoping for in this case. Good lawyering, clear answers, which is why when we see good lawyering, I am going to pause and call it out on both sides. The defense attorneys are incredibly skilled. I think all of us can take some of the things they do, and you can see the moment that they push too far, it's like, but it's their job to push. It comes across more heavy-handed when the state pushes, like you've got the full weight of the government behind you. The defense has a little bit more room to push, and that's their job, is to push. Their job is doubt. That is their world. The prosecution has to prove to us how this happened, and we're barely started. So I'm trying to keep an open mind, but with those opening statements, the questions that the defense posed in those opening statements are what I find staying in my mind, because the prosecution was not as clear an opening as they were today in the jury view. The prosecutor was much clearer on what they wanted the jury to look at in the jury view. And I'm trying not to be too hard on the prosecution. I realize that there are times where I lean harder on prosecutors because it was like my job. And so there's times I'm like, I know what this job takes. But there's trials where I know I've not been great. There was a trial when my husband was in the hospital and I was like, I'm sorry, what did I just ask? And I'm like looking at my notes and I'm like, Emily, you have to keep asking questions. So you never know. But this is a very high profile trial. The victim's family, this entire community, and the defendant deserve answers. And this trial deserves to be done well. So everyone deserves answers. And I hope we will see that at some point. Autumn Fall Winter said, sorry, I'm not a lawyer or in law school. That's okay. I don't understand the finite rules of foundation regarding the photos. I just love the channel and you make court and laws so juicy. Just curious for better understanding. You have to prove where a thing came from and that the thing is what it says it is. So if I went and printed a photo off of Twitter and brought it into court and was like, this photo says it's that, I have to prove where it came from, who's in it, how we know it's true. It might be as easy as somebody saying, oh, I took that photo, I know that photo, and explaining it. Or the witness saying, oh, I remember that. It was this event. It was this photo. I don't remember who took it, but that's me and that's them and we were here. That might be enough in some circumstances. But generally, you need to subpoena it from the social media network and say, I need all of the backup data of this photo. And when photos are put up on social media, you don't have the same metadata as like when they're originally taken. So you can't just print something out and bring it into court. You have to verify that it is what it is. And there's a lot of different rules to allow them to do that and a lot of different ways that can be done. but you have to show how it's done. And the defense might do that later. They might do that in their own case. They might bring in the person who took the photo. We never know. But yes, you have to prove the thing is authentically what it is. The rules on photo. Oh, Emily, don't. Keep it quick, girl. Keep it quick. Keep it quick. The rules on foundation and digital evidence are going to be something that courts, I believe, will be getting more strict about in the era of deep fakes, altered images, edited images. It's going to be something that courts have very, very little patience for. And you are going to have to show very thorough foundation and to show that evidence is not altered. So you have to know where it comes from. And that's just because of the rise in how easily things can be altered and how difficult it can be to perceive it, to make sure that things coming into court are only the actual thing. So this is something courts are going to have to struggle with. Lawyers oftentimes are very bad with text, so are judges. It's going to be difficult. So we saw lots of discussion about photos, altered photos, and what have you in Depp v. Heard. We're going to see it in other cases. Sometimes it's as easy as, in the Murdaugh case, there was a Snapchat video and you saw the custodian of records come in and be like, yes, I'm the custodian of records. We downloaded this from this account. It was uploaded at this day, uploaded from this type of phone. And then you had other people come in and identify the voices on all the video and identify the people on all the video. So we knew the video came from Snapchat. We knew what phone it was taken from on Snapchat. We knew what account posted it. We knew that account connected to Paul. And then we knew that Paul's voice was on it, Maggie's voice was on it, and Murdaugh's voice was on it. But it took like 3 witnesses to get there on the Snapchat video. So you have to lay that type of foundation. I don't ever mind you guys asking that. I think it's important to understand because foundation of evidence is going to be more and more important as we get into an era of, Elvis Presley singing Baby Got Back, and it sounds dead ass like Elvis Presley singing Baby Got Back. Vermillionaire said, is Proctor Karen Reed's version of Mark Furman? Very well might be. I can't ignore the thought there. Jury view also happened in the OJ case. Jury view also happened in the Murdaugh case. Most defendants don't go on a jury view. Security is always an issue. Overhearing conversation with the lawyers is an issue, but security is the main issue. I've never seen a defendant go on a jury view. I worry that because this is a public neighborhood, the public will be at the jury view and that will be an issue. We'll see. Becca says, is it my ignorance of judicial process just fueling my bias, or does this judge really not like Attorney Jackson? I don't know yet. Becca. I'm waiting to see how it goes because the defense can push a little bit more. I'm waiting to see if it's disproportional, but we're waiting. Brianna said there's a reason she doesn't want Jackson dropping nuggets for the public. The jury doesn't know. If you've avoided coverage, it's a mystery. I'm sure we'll see it if it comes out. It's 15-minute drive from the court to the scene. Good to know. I don't think they need the pictures to come in. If they asked me about being in a pic with someone, I can tell you at least the event and why we were there. I mean, I don't know my memory, how it would or would not, but generally yes, unless it's common practice to go to the beach and be like, I don't know. I spent an entire summer at the beach with these group of people. I can't tell you it was one day versus another day, but then you would generally know the location. So the jury will get to decide all of that. How do issues come up on appeal when the objections are without the grounds? I don't know if the judge notes it in their notes that become part of the record. I don't know. Also, the courtroom set up for the English courts by colonists. Yes, it is. Thank you from a Boston 1L. Congratulations, Kelly Kell, on your 1L. And you see the legal history and traditions come in that courtroom, don't you? Especially with the God Save the Commonwealth. It was so funny. Runkle was talking yesterday. Nobody told me this earlier. I literally might have moved and applied for citizenship, but nobody told me if you're a prosecutor in, Canada, England, that you're not like the state. Like, it's so like, good morning, Your Honor. Emily D. Baker for the state is like, or I would often say for the people, but you get to be the crown. I don't know. Maybe it's because I'm so American that seems amazing, but it's like, oh, the Crown said this, the Crown said that. It's like, really? The prosecutors get to be the Crown? Come on, that's kind of cool. That's kind of cool. Destiny said the injuries aren't consistent with the car, especially not on the arm. We're not there yet. I'm not saying that you're wrong. We're just not there yet. But we did learn today. Ooh, I forgot to mention this. We did learn today, Miguelina, we need to put this in the summary too. We did learn today that for the first time, one of the fire medic witnesses indicated that there were no holes in the victim's clothing, which will be really interesting because if there are fresh injuries on the arm, how are the clothes not torn? So we will see. But that was interesting. Brittany said group photos are a far cry from when I went to high school with a girl with that name. Okay. Yes, they are. Are a far cry from I went to high school with a girl with that name. Yes, they are. And it was interesting because the witness was like, I know someone by that name is very different than we run in the same circle. It is. It's a very different thing. Emily said, is it normal for the state to constantly try to prove the defense wrong instead of proving how Karen Reed did the crime? In redirect, the goal is to rebut what the defense has just said. In direct, it should be very much focused on their own case. So the defense's opening was strong though. Gifted 10 memberships. Thank you, Bone Arrow 82. Charlie said it's the Crown in Australia too. How fun. Charlie, I forget that you're in Australia. That is so fun. That is so fun. Look, all the things aside, I am just going with 12-year-old Emily being like, hee, Crown. It's different than being like, for the people. Sassy Eric said, so far this case is about as clear as mud or yellow snow. However, I do feel like I'm getting a better picture so far from the defense. Sassy Eric, I'm right there with you. I think most of us are. She doesn't remember because she was underage drinking. I mean, who knows? Luna said, I came in knowing nothing. McLaughlin seems super sus to me. I think a lot of you in the chat were like, ma'am, like, wouldn't it be different if that witness was asked about Caitlin Albert and said, I went to high school with Caitlin Albert. We ran in the same circle of friends and have a lot of mutual friends. Wouldn't that seem more clear than I know someone of that name? Right? The way it was answered is what the jury will have to decide. Cindy said, I live in a small town and the defense has pictures with people I'm not close friends with that I graduated with, not a smoking gun for me. And it might not be. It's a puzzle piece. It's one of the multiple puzzle pieces. This conversation might all be forgotten by the time we get into late next week. Ugly Planet said, this is my ticket for a Google Street Map trip. I mean, everybody knows the address of where the crime happened at this point. In some UK trials, counsel says King's Counsel. That's fantastic. Does it change? Would it be Queen's Counsel when it's the Queen and King's Counsel when it's the King? I would imagine it would. I would fuck that up all the time. Blake said, Matt, it's big groups, could be anything. I wonder if for some, the way she answered initially and then the backpedaling will matter more. Like if she had just said, yeah, we have a lot of mutual friends, if that would matter less to the jury than her distancing herself and getting pinned down on it. Judy Ron says, hopefully some a-hole doesn't take pics or photos and post it on social media. I really hope not. They said they've got 100 feet, but I worry in high profile cases. I think you let the jury make their decisions without fuckery. I worry. Tiffany said, what is with the dang fan? I don't know if there's any pictures in this courthouse. Truly. Every single EMT says they elicited the statement. Sally, yeah, they did. The defense is definitely going to point it out, isn't it? New definition to only fan. Only fan. Angela said, watching a little behind, but no tears in the winter jacket, but furrows on the arm. I still don't know if we have a winter jacket or not, honestly. Mike said, Emily, thank you for all you do. Look, we've heard somebody call it a hoodie. We've heard somebody call it a fluffy jacket. We've heard somebody say it was like a thin zip up. I don't know. I am not clear on what clothes the victim was wearing. And what I remember from opening is that there was conversation of Karen Reed trying to cover John up to warm him up. So I don't know if moving that jacket was the moving of the jacket. I just don't know. The testimony was not clear or consistent. So I just don't know. Let's see. Gifted 5 memberships. Thank you, Lori A. It was nice of you to buy a new TV for your cats. They're so fascinated by it. The cats are very, very happy with bird watch on the Cornell bird, which I'm going to just put on right now. They're very happy with the Cornell bird feeder cams. Very happy. Cornell on their the Cornell Lab bird cams have a whole bunch of live bird cams every single day. They've got like owl cams and like albatross cams. I particularly generally watch the Cornell Feeder Watch, which is at Sapsucker Woods. That is the one I prefer. And it's fascinating. Oh, they put out new oranges this morning. But yes, the cats are thrilled. What happens when the judge was asked to recuse herself more than once and she denied more than once? What can happen in the case? I did not see any of those hearings. If there is a conviction, it will come up on appeal. Knowing, well, I don't know the circumstances of the request for recusal, but if there is a conviction, then it will come up on appeal. I mean, sus that the Commonwealth didn't do their homework and not the defense handing it over. It depends on where it came from. And if it's impeachment, I don't know I'm not clear if they have to hand it over because it's not their main discovery. And that was Alan's argument. The court denied it. I'm not a Massachusetts attorney. So we'll see. You can enter unvalidated 6-month-old, easily editable screenshots as evidence, but you can't use photos that haven't been validated and backed up by metadata. I don't think you can enter any of that into evidence. So I'm not quite sure what that is referring to. I don't think you can enter any of that. Carefully, y'all, McDonald's brewed this hot tea. It was hot. It was definitely hotter in the voir dire, which the jury didn't get to see. I'm going to start singing, you got what I need. Will you say he's just a friend? Will you say he's just a friend? Frank said 213 people graduated in 2014. That is a small high school class. Crime Time said, can a witness say they feel like they are being led? Like the lawyer is forcing them down a hole? That's the whole point of cross-examination. And if they see the cliff coming, they look. That's the whole point of cross-examination. You don't get let off a cliff if there's no cliff to be let off of, though. So, you know. Just call me Henson. Can we take a road trip via Google Maps? I'm not going to. I'm not going to tell you guys not to. The jury will have seen it because I've got some stuff I need to do as we wrap up and take the lunch break because I have some meetings and I have to blow dry my hair before our banquet tonight. And I don't know what time court's going to be done. You'll see this afternoon if I've had time to do that. I got to go see if I have pants. I might need to do laundry too. Lou said Emily needs a laugh. Here's one. 3 attorneys, a murderer, and a turtle walk into a bar in South Boston. Wouldn't that be extra info not asked, though? I don't remember exactly what that was referring to. Thank you for your excellent coverage. Well, Sandy, thank you. Autumn, fall, winter. Thank you, Emily. So interesting. Photo Foundation sounds extremely complicated. Now I know it. It depends. If you have the right witness, it's not extremely complicated, but a lot goes into it. So yes, a lot goes into it. Jordan says, have we gotten to or touched on other people who had motives to kill the victim? Not at all. And I expect we won't until the defense case. Nope. Sonia said, I think they're trying to show how many connections the Alberts have. I think so too. Not just connections with officers, but with first responders. I think so too. However, this is why local juries matter. The jury will know, right? I mean, you know, when it's your town, you kind of know. So we'll see what comes of it. But again, the jury will have more context for this just from their lives. Emily, this judge was asked to step aside because of her connections to people in the case, but she declined. If there's a conviction, I'm sure that will come up. Your Honor, is the court clerk going on the jury view? Can she talk to the jury? No. Lisa H said, isn't it kind of early to go to the scene? It seems early, but I don't know. Does Karen have to go? Karen is not allowed to go. They decided that security was going to be too much amongst other things. Do they close off nearby streets? I don't know. Do juries often go on field trips? It only if it's helpful. Like in the Idaho case, they won't. The house has been demolished. In Murdaugh, they did. Sometimes you need a sense of the size, especially when it matters. Like it matters very much how a car backed out and which way cars went. And if there's video of which way cars went, all of that matters very much in this case. In another case, if somebody gets robbed on the street and they're like, this person robbed me, it's that person right there, and there's a ring camera footage or a footage from the grocery store across the street or whatever, it's less important that the jury have a layout of it, but how the mechanics of how this happened really matter. Hi, George. In my hometown, we have you have to live in city limits to be a city cop, firefighter, or paramedic. I doubt those who live there will care that she knew her. And some jurisdictions are like that, some aren't. Not Dr. B's government name. You're in trouble. I mean, I can smell the Brussels sprouts. I like them when they are baked or roasted, not when they are steamed. They smell awful. Emily said, it feels like the state is spending so much time trying to prove it's not a cover-up by law enforcement, but zero time showing how Karen Reed did this. We're a week in. We haven't gotten far. As a juror, her being less obsessive with the prosecutor would make me question her testimony. Oh, defensive? I think yes. 3 elementary schools in Canton, so they might have not gone to school together. All right, let's see if there are any other questions. Does anyone feel like Mark Wahlberg or Matt Damon is ready to make a movie? I have heard that there are cameras in the courtroom for Netflix. So we'll see. Stephanie said my high school graduating class was only 51 or 52 in 2014. That's a small class. That's the kind of class where you're like, I can't date you. I've known you since kindergarten. Like just nah. Lynn said in the Kowalski case, the expert admitted and in Voir that he never received 3 actual reports he testified about, just summaries provided by the defense. Fireworks. That would have absolutely been fireworks. My high school graduating class was only 89. That is a small class. Perhaps Elaine sued Lolly for copyright. Hey, that's my phrase. You guys can Google. I'm not going to. EMT is a pool boy and Legally Blonde acquaintance. Does the judge determine if foundation was proven? Yes, but they haven't tried yet with the photos. Can she not allow it? And then what are the defense's options? They made a record on the Rule 14 stuff. They haven't tried to establish a foundation. They asked the witness if she recognized them, and she said no, but she did recognize herself in them, which is why they were allowed to question her on them. I think it is, I think it's going to be sufficient for the jury. They now know that she downplayed that they knew each other. I think that's the point that came across really strongly. George, if you jump at that TV, I swear, kitty cat, this is what George is doing at the moment. So that's what's happening for the cat cam. So he's just hanging out, waiting for the Blue Jays to come back and get after the peanuts in the bird feeder. All right. With all of that, you guys, I'm not sure what time we will be back. 1 or 2 p.m. Eastern time. I have some meetings this afternoon and some stuff to do. If court comes back and I am not back streaming yet, do not fear. I will be back to catch us up for sure. So I will be back. I will put it on the app when we are back. I don't know how long this view is going to take, and the court has not told us. And the defendant needs time to get back, and they still need time to eat lunch. So this is not going to be a quick process. LawNerdApp.com. Make sure you're subscribed and hit the bell here. I will tell you when I'm back live. This is a full court day, so we will be back this afternoon. For all of the members, I will be putting up polls in the member spaces about next week's podcast, and I will be putting up information about the members Zoom call for those of you that are at the top tiers. That the Zoom call is on Saturday. Nikki, I do not live on a river. This is not me. This is the Cornell bird cam at Sapsucker. I wish this was the view out my window. It is not. Would I put the view out my window up? No, because then somebody would probably, well, Emily, have you already been doxxed multiple times? Yes, but I think it would create issues. But I love the bird feeder cam. It is a nice change of pace. So, and George loves it too, now that it's on, the wall. So with all of that, I appreciate you. Get the app. I'll be back this afternoon. Yes, court might go back right before I get on live. We always manage to catch up because of the breaks they take in court. And with all of that, Law Nerds, you're the best. Members, I will put stuff in your member spaces, and I will see you after court gets back from the jury view. So 2 o'clock, 3 o'clock, we'll see. Bye, y'all. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.